I really respect him because he has a deep respect for the rule of law. He doesn't have an agenda when he decides cases and writes opinions, but he does have a perspective, and his perspective has been shaped by his life experience. For those of you who don't know his story, he was born in California to immigrants from Japan. During World War II, when he was 8 years old, his family was uprooted from their Los Angeles home and incarcerated in the Poston-War Relocation Center in Poston, Arizona, one of 10 concentration camps set up during World War II in the United States for Japanese Americans, none of whom received any due process at all. It was an experience that Judge Tashima described as being stripped of all one's dignity and earthly possessions and forced into exile and imprisonment solely because of one's race or ethnicity. Poston also happens to be the same camp where my mom and her family were imprisoned, so I'm familiar with the devastation it wrought on all those families to lose their homes and everything they owned. After the war, he continued his education and later enlisted in the Marine Corps. He subsequently graduated from UCLA as an undergrad and went on to Harvard Law School, where he was one of only 4 Asian Americans in a class of 500. And although he graduated from one of our nation's top law schools, many private law firms told him they would not hire him because of his race. So fortunately, he was offered a job with the Attorney General of California, and he later was a partner at Morrison & Forster. However, even when he worked at a private law firm, he sometimes encountered racial discrimination from clients who did not want him as their lawyer solely because of his race. In 1980, he was appointed to the U.S. District Court for the Central District of California by President Carter, and after serving as a district judge for 15 years, he was appointed to the Ninth Circuit Court of Appeals by President Clinton, becoming the first Japanese American to serve on the U.S. Court of Appeals. But despite the discrimination he has faced, both blatant and subtle, he doesn't complain, he's not bitter, and he unfailingly displays calm and equanimity. His life experience has left him somewhat skeptical at times about the motivations of the other branches of our government. Nonetheless, he is always committed to following precedent, but with an eye toward the oppressed and with a bent toward compassion. I believe that he is committed to justice. Judge Tashima has overcome adversity to achieve the heights in the legal field. He is respected by his colleagues and admired by his clerks. He is leaving a legacy that he modestly describes as being you, his clerks, who have gone on to have your own legal careers, teaching, judging, working in private practice, and in government agencies. So Judge, I know you hate this, and I apologize again, but now that I have you stuck here, I just want to tell you that I love and I respect you for your intelligence, your legal mind, your commitment to justice, your even temperament, your modesty, your kindness, and your sense of humor. Now relax and just enjoy listening to some very illustrious colleagues discuss your work and your impact on their lives.
So I'm just going to quickly explain what we envision for the day. The purpose, of course, is to celebrate and memorialize Judge Tashima's contributions to the law and the legal profession. And so following Judge Nguyen's keynote address, we will have 3 panels. The first will focus on the way in which Judge Tashima has shaped the law and legal doctrine. The second will focus on Judge Tashima and the art of judging. And the third, and these are rough approximations, but the third will look at Judge Tashima's impact as a mentor and role model. So each speaker will be speaking for approximately 15 minutes, which leaves a little bit of time at the end of each panel for people to offer their own thoughts and observations on the general subject matter of those panels. One day's worth of panels can't possibly do justice to these topics, but we hope that collectively and together, the panels will paint a sufficient picture of what makes Judge Tashima such an important figure in our profession. And with that, I'd like to introduce UCLA's Dean, Jennifer Mnuchin. Thank you so much for being here at our event.
Good morning, everybody, and thank you for being here. And particularly, I do want to thank Scott and Kaipo and Candace for both kicking things off and for all the hard work they, along with everybody that Scott mentioned earlier, put into the organization of today. I think it's really terrific that we get this opportunity to celebrate all that you've done and to do that here at UCLA Law School. You may not be our graduate, but you are a Bruin, and we are delighted to bask in that connection with a nod toward Cambridge as well, which gets to claim you too. So welcome everybody. One of the pleasures I have as dean of here at UCLA is to get the chance to welcome people to events like this one, and it's genuinely and deeply an honor to greet you all today and to thank you for taking part. We are here to celebrate the career and the ongoing legacy of a truly towering figure in the law, Judge A. Wallace Tashima. And you've already heard a little bit about the ways that he's had such a profound impact on so many people, both as individuals, but also on the Los Angeles legal community, the Asian American legal community, the Ninth Circuit, and the making of federal law across this country. Candace described in her remarks Judge Tashima's remarkable story, his personal story, and some of the ways that he has brought such an ethic of compassion and service to all that he has done. And I know him much less well than all of you. In fact, really not very well at all, except we were neighbors when I was very little. We lived 2 blocks away when I was much too small to appreciate it. So I'm only sorry that back during your stint in Berkeley and my family's stint in Berkeley, when we were literally 2 blocks away, which Judge Tashima remembered, that I wasn't old enough to get to know you then. But I'm so delighted and honored to have you with us today. He's been a mentor to so many, and that includes, of course, here at the law school, a number of our graduates and this event's organizers, as well as UCLA professor Elaine, who also clerked for him. And so thank you for your connections to UCLA and for making us one source of fantastic clerks who can learn from you and continue your legacy. That means a great deal to our school. And thank you also for the way that you've been a champion of civil liberties, a champion of the rule of law blended with compassion and empathy, and a focus on making real difference. I can't tell you how much that means. Today's discussions will explore his record of achievement and his guiding philosophies, but also some of the ways that he's made a difference personally. So that's really what I want to begin by saying, but I think we should all just give a round of applause before we've even started for Judge Tashima and all that he has been and continues to be to everybody in this room and so far beyond. It's now also my very great honor to get to introduce our keynote speaker, Judge Jacqueline Nguyen of the U.S. Court of Appeals for the Ninth Circuit. Judge Nguyen emigrated with her family from Vietnam when she was a child and also grew up in Los Angeles. She earned her undergraduate degree from Occidental College and then is a distinguished alumna of our law school, UCLA Law, and is a member of the class of '91 and certainly very much one of our shining stars. She has been a longtime and very distinguished fixture in the Southern California legal firmament, first in private practice, and then as an assistant U.S. attorney. And then in 2002, Judge Wynn, like Judge Tashima before her, embarked on a number of firsts, which we can be both proud of her for, but also sorry that some of these firsts have taken as long for our country as they have. She was the first Vietnamese American woman appointed to the Superior Court here in LA County. Then, after she was nominated by President Obama to the Central District in 2009, and then elevated by him to the Ninth Circuit in 2012, she became the first Asian American woman on a federal circuit court. Judge Wynn's tenure on the Ninth Circuit has been marked by an unwavering commitment to fairness and civility. And in this respect, I think the two of you have much in common. You might have heard her make those lists of potential Supreme Court nominees a few years ago. We're in a different political moment now, but still, we're proud of that, and we love the fact that you that we. What can I say without being too political? In my role as dean, I'm not allowed to say some of the things I actually think. So I'm just going to say that we're honored that you are in your current role, and we look forward to times when that might be a possibility again. But I'm going to stop now as I'm twisting myself in circles here and say that we're thrilled to have, when I called to ask if she'd consider doing this keynote, she accepted on the spot and said it would be her enormous honor and that she just hoped that she could do justice to Judge Tashima. And I think that is a hard task because he has done so much. But I also know that there is no doubt that you will do that and more. So thank you so much for being with us today. And without further ado, let's give a warm welcome to Judge Jacqueline Nguyen.
Thank you, Judge Wynn, for those wonderful and poignant remarks, and for all you do for justice and for all you do for our law school. I think we're going to roll right into panel number one. We built in a little bit extra time, but I think we will take that extra time to have a more extended lunch and move right into the first substantive discussion for today. So again, I want to thank you all for being here and for allowing me to play a double role on this particular panel, our first, both as a participant in the panel and as a moderator. As a moderator, I want to begin by just thanking our incredibly distinguished group of panelists to whom I feel a very special set of connections, which I'll tell you about in a moment. And it makes it a particular thrill to be on the panel with them. I want to briefly introduce them, and then each will get about 15 minutes to make comments, and we'll leave some time at the end for questions and answers. Before I do, again, let me just set the frame for the panel, which is about the impact of Judge Tashima's jurisprudence. So how his work as a judge has in fact advanced legal doctrine, right, advancing legal doctrine in key areas. And the areas that are highlighted in this panel are comparative administrative law, environmental law, procedural justice, due process, racial justice, and labor rights. To talk about these subjects, we have amazing scholars and jurists, all of whom are Judge Tashima's former law clerks. The person who has traveled the farthest and who has the benefit of the biggest change in temperature is, he says it's negative 37 degrees Celsius in Ottawa, Canada, is Adam Dodek, who is the Dean of the Common Law Section and full professor of law at the Ottawa Faculty of Law, which he joined in 2008. I have to say I feel particularly honored to share the panel with Dean Dodek, who happened to be my law school advisor and legal writing instructor when he was a 3L and I was a 1L in law school. So any writing skill that I can claim is all owing to Adam. Thank you. We also have Gail Feuer, who is an associate justice on the California Court of Appeals, 2nd District, and before that she served as Los Angeles Superior Court judge, appointed in 2005, after a decade of distinguished work as an environmental lawyer at the Natural Resources Defense Council. Kaipo Matsumura is an associate professor of law at Arizona State Sandra Day O'Connor College of Law, where he teaches and writes about civil procedure, family law, and reproductive technologies and the law. He's a decorated teacher and scholar, was chief articles editor of our UCLA Law Review, and graduated from the Law School Order of the Coit in 2007. And Joy Milligan is assistant professor of law at the Berkeley Law School, where she does interdisciplinary research on race-based economic inequality. She teaches civil procedure and anti-discrimination law. Before joining the Berkeley faculty, was a Skadden Fellow at the NAACP and a graduate of Berkeley's Jurisprudence and Social Policy program, among other institutions. So I want us to all welcome our distinguished group of panelists. We're going to, again, turn it over to them. Each is going to have about 15 minutes to talk, and then we'll open it up to Q&A. And we're going to start with Adam. You can do what you like.
Thanks very much for that introduction, Scott, and thank you for inviting me to come here today. As you can imagine, getting an invite to come to California, to Southern California, at the end of January is very appealing. It was a good idea at the time, and this week with 2 snowstorms, and as you heard, minus 37. I don't know what that is in Fahrenheit. It's horrible in Celsius. So it's great to be here. You know, I had the privilege of clerking for Judge Tashima in 1997-98, which I think was his 2nd year on the 9th Circuit. And it was a great year for me. Like most of us at the time, I was young. And I was a newlywed living in a bachelor's apartment in Pasadena. which now seems rather cool since the rise of, and the notoriety of the Big Bang Theory. Like many of us, I was trying to find my way in the world. I was also trying to figure out what country I wanted to make my life in. I have the privilege of being a dual citizen of the United States, where the country that I was born in, and Canada, the country in which I grew up. Ultimately, after my clerkship year, I would return to Canada with my devoted spouse, who had followed me from Israel to California and then on to Canada. Her famous last words when the thermometer dipped to 56 degrees one day here, she asked, "It's not going to be colder than that in Canada, is it?" Well, my clerkship with Judge Tashima was sandwiched between two other appellate court clerkships in two other countries. I had earlier clerked for the Supreme Court of Israel, and 2 years after returning to Canada, I would end up clerking for the Supreme Court of Canada. After that clerkship, when I was interviewing for a quote-unquote real job in a law firm, a partner introduced himself to me with the line, "Oh, you're the guy that can't keep a job." Those experiences early in my career helped frame my views of the law, of the judicial role, and of access to justice. Judge Tashima and the U.S. Court of Appeals for the Ninth Circuit played a big part in that. He and the court helped me to see contrasts between the systems and to question them. When I look back now as a law professor, and I think about the role that Judge Tashima played, and hearing from people so far today, and looking at all of you, I realize not only was the judge a mentor to all of us, a role model to so many students, but he was a teacher to all of us in his chambers. And as a judge, part of the role of a judge is to be a teacher to the public, but in everything that he did, in every interaction with us in chambers, he was very much a teacher. And he taught me what the rule of law meant, about the importance of respect for the rule of law, and we've heard about how the rule of law needs to be tempered with, very much with, empathy. Strangely, in some ways, clerking for the Ninth Circuit was a lot like clerking at the Supreme Court of Israel. Despite its existence or status as the apex court in the state of Israel, the Supreme Court of Israel looks a lot like the Ninth Circuit. It hears 8,000 cases a year, a mixture of appeals as of right and judicial reviews of government action. The Chief Justice of Israel, Aharon Barak, famously said that the world was filled with law. There is no corner of human behavior that does not escape legal scrutiny. The result of this Barakian approach to law was to significantly curtail doctrines of standing, rightness, and deference or standard of review. The political questions doctrine barely exists in Israel. I contrast that with an American approach reflected in the decision that Judge Tashima wrote in his first year on the Ninth Circuit. In San Diego County Gun Rights Committee versus Reno, he affirmed the district court's dismissal of a pre-enforcement challenge to the constitutionality of the Crime Control Act on standing and rightness grounds. He noted that Article 3 of the U.S. Constitution limits the jurisdiction of federal courts to cases and controversies, and that standing is an essential core component of the case or controversy requirement. As I reflected upon this, I noted that surprisingly, for a long time, Canada's approach to standing and rightness was very similar to the U.S. approach, despite the fact that there's no similar limitation of cases or controversies in the Canadian Constitution. And that's something I had really never thought about before. But now, having had time to reflect and think about what I learned from Judge Tashima and the experience of clerking, I had the opportunity to reflect a little bit on the relationship between form and substance. And as I look back 20 plus years, I distinctly recall that the first sections of the bench memos we would prepare for Judge Tashima, the first would be an overview, and the second would be entitled Jurisdiction. The third, I think, was either analysis, where the first part of it was standard of review, or standard of review sitting on its own. The point is that jurisdiction always matters to federal courts, the U.S. federal courts. In San Diego County Gun Rights Committee, Judge Tashima quoted an earlier Ninth Circuit decision that stated, quote, "Federal courts are presumed to lack jurisdiction unless the contrary appears affirmatively from the record." We know, as law students, in the very first days of law school in civil procedure, we study jurisdiction. We know about the critical relationship between the U.S. federal court system and the state system. Now, Israel is a unitary state system, so you would think that issues of jurisdiction would not arise. But they do arise because there's a separate religious court system for 9 different recognized religious communities. Questions of jurisdiction arise, but not with the frequency or the centrality as they do here in the US. Canada, like the US, is a federal system. There's a separate federal court system, much less prominent than in the US, as well as provincial court system. But in Canada, Canadian courts and Canadian judges take jurisdiction for granted. There's far less challenging or questioning of jurisdiction. I want to turn next to the issue of standard of review, with an admission that is somewhat embarrassing for me as a public law scholar, and I hope will not be embarrassing for Judge Tashima. And that's the admission that in law school, I actually did not take administrative law or US federal courts. It wasn't that I wasn't interested. The course had a reputation as being a really, really difficult course, and I was intimidated. Nonetheless, Judge Tashima hired me, and I underwent on-the-job training with him. And what I recall is that he took standard of review very seriously. This is perhaps not surprising, as he had been a trial judge for 16 years before he became an appellate judge. We hear a lot of talk about deference to triers of fact, but I learned from Judge Tashima what this meant. At times, in discussions with him over a case, he would say that, well, he might not agree with the result, but he hadn't been there and he hadn't heard the evidence the way the trial court judge had. When we discussed cases, he took a serious interest in what the applicable standard of review was. Substantial evidence, he would ask, not asking much more than that, and he taught me what substantial evidence means. In a decision where he wrote, he said, it's relevant evidence if, considering the record as a whole, a reasonable person might accept as evidence to support a conclusion. It does not require a preponderance. He also understood and articulated what clear error meant. As he explained in a case called Cree and Flores, quoting the US Supreme Court, a finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire evidence is left with the definite and firm conviction that a mistake has been committed. When there are 2 permissible views of the evidence, the fact finder's choice between them cannot be clearly erroneous. Now, it's not uncommon in the US federal courts to find debate and disagreement about the appropriate standard of review, but there is general consensus on the content of long-established standards of review. I would suspect that most of you probably take that for granted. Coming from Canada, this is not the case. Canadian courts, and the Supreme Court of Canada in particular, have been unable to figure out standard of review. It's the pathology of the Canadian public law system. The Supreme Court of Canada is obsessed with it, but cannot figure it out. In the year that I returned to Canada in 1998, the Supreme Court decided a landmark case on the standard of review to be applied to decisions by administrative officials. In this case, a decision by the Immigration and Refugee Board of Canada. The issue of standard of review had not even been argued before the court. That didn't stop the Supreme Court of Canada from addressing the issue. Again, perhaps another difference from Canada and the US. The Supreme Court of Canada tried to clarify the standard of review and adopted something called a pragmatic and functional approach. And it created three possible standards of review: correctness, reasonableness, and patent unreasonableness. The court said that these were 3 points on a spectrum of judicial review, and the pragmatic and functional approach, which would be used to determine which of the 3 standards of review applied, itself had 4 categories and 3 subcategories. This was a lawyer's nightmare, a law student's nightmare, and a law professor's dream. Of course, it proved unworkable in more ways than one. To begin, no one could quite figure out what the difference was between unreasonableness and patent unreasonableness. In a matter filled with irony, the leading case on patent unreasonableness involved the dean of law, not at my law school, at another law school, but his decision to suspend students for academic fraud. And the choice of the language of spectrum was also unfortunate. In a case that I was involved with, a provincial court of appeal, much like the US Court of Appeals, had held that the spectrum meant that the standard of review could be anywhere on that spectrum, that there weren't 3 possible standards of review, there were an infinite number of standards of review, and the standard of review to be determined for a decision maker could depend on what the particular decision maker was. The Supreme Court of Canada quickly put an end to that, but not to the confusion. And in 2008, it reduced the possible standards of review to 2, correctness and reasonableness. But this didn't end the confusion, however, and in the fall of 2018, the Supreme Court of Canada heard a trilogy of cases with a goal of yet again revising the standard of review. I bet you never thought that American administrative law was so clear. What does this all mean? My point is that comparative law and comparative experience allows us to ask questions about our own legal systems. Judge Tashima loved to travel. Our year, he was invited to hold a hearing in Missoula, Montana. It required 2 flights and several hours car drive. Judge Tashima invited all of his law clerks to accompany him. Tom Hickson, Candace Yokomizu, myself, Shannon, all of us took a pass on that. He also continued to sit by designation as a district court judge that year in Tucson, which is great, but it was in August. I think again we passed. He was a great traveler, but also a great teacher. His ideas and his views on the law have also traveled. They've traveled with all of us, and perhaps surprisingly, I think, for him, they've traveled with me, and I'm trying to use what I've learned from him to the extent that I can in my scholarship in Canada to try and bring some clarity to the law in the area in which I work in. Thank you very much.
Good morning. So I, too, am delighted to be here, but I feel a little older because I clerked in 1984, so I feel that's a little bit Middle Ages. My recollection from my clerkship is back then we had an IBM Selectric typewriter. There was no such thing as a computer. We used to type our memos, and then if we had another memo that had the same summary judgment standard, we would take a scissors and cut it out, piece it together again, and then we did have a copy machine, so we could then copy it and give this pathetic memo that was at different angles to Judge Tashima. So I feel a little bit like the Middle Ages. I have to tell my kids that story, they would really think I was from the Middle Ages. But I have to say, I would not be a judge today if it was not for Judge Tashima, because after spending a year watching and learning from him, at the time was a district court judge, and I think I was the 5th year that you had law clerks and had been on the bench. it became very clear to me that judges make a huge difference, and that a smart, fair, and thoughtful judge would make all the difference in whether the parties receive justice. And I think you'll hear that from all our panel members today, who all served as clerks, and many who also appeared before Judge Tashima. And it was actually back in 1984 that I decided that that's what I wanted to do when I grew up. And it still amazes me today that I got to do it. And Judge Tashima has been supportive of me all the way, including coming to my confirmation hearing in July. So this has been a wonderful journey for me, and I would not be here today but for him. So environmental law. I did spend about 20 years practicing environmental law. And when Candace called me, I said, well, maybe I'll talk about environmental law. So I read all of Judge Tashima's opinions on environmental law, which I had not done before. There were about 80 I pulled up on Westlaw. Not all of them were directly on environmental law, but I was searching, using search terms like Clean Water Act, Clean Air Act, Endangered Species Act. The interesting thing is I was doing that, I was thinking this is a really smart and generally progressive jurist. I'll find all these great cases for the environmentalists. Well, interestingly, as I was reading all the opinions, I realized the vast majority ruled in favor of the industry. So I started to have second thoughts, and I was thinking, is this the topic that former NRDC lawyers should be talking about? And the answer is yes, because I realized as I read the opinions, it was absolutely consistent with the theme of today, which is the rule of law, which is the environmentalists are not always right, as many people would say today without getting too political. The government is not always right, and it was interesting in reading the opinions, and actually today I want to talk about some of those opinions, and actually most of them were for the industry groups, but they upheld important principles of environmental law. So for a moment I did start to research search and seizure, but I decided to stick with environmental law. So first you should know some important facts about Judge Tashima. As I was reading this, I learned that he has now become an authority on the flat-tailed horned lizard, the southwestern willow flycatcher, the Idaho bighorn sheep, and the Arizona pygmy owl. You'll be tested on these later. I'm going to come back to some of these, but it was interesting. I actually had not known that you had written so many opinions under the Endangered Species Act, which is very interesting. So the first environmental case, and Judge Tashima can tell me later if there's one before this, but the first one I'm familiar with from his writing on environmental laws was actually just before I was a law clerk, which was in 1982, which was American Motorcycle Association versus Watt. For those of you who are a little older, you'll know what Watt means, which is James Watt, who was, I see a lot, some of the older heads shaking their heads saying, we remember James Watt, who was the Secretary of the Department of the Interior. And at the time, this was a lawsuit by environmental groups challenging the Bureau of Land Management, I'll call them BLM, but BLM's designation of routes in the protected desert for off-road vehicles. And the environmentalists had sued, and in a very well thought out opinion, Judge Tashima wrote that its decision was arbitrary and capricious, and had issued an injunction to the environmental groups because the Department of the Interior had decided that it would decide on what was a protected route or not, based on the standard of whether there were considerable adverse environmental impacts from the routes, when the standard under its own regulations was they could only approve routes if there were no adverse environmental impacts. So it was an opposite standard. Judge Tashima issued the injunction, and I assume motorcycle enthusiasts who want to ride off-road vehicles won't be here today joining us in celebrating his work. But his first foray into environmental law in a very well-reasoned opinion, and when I was a law clerk, that case was still going, as they often do. So I'm going to talk about 5 cases today. The first 2 cases are Endangered Species Act cases. One is Tucson Herpetological Society versus Salazar, which is the one about the flat-tailed lizard. This was and the second one is National Association of Homebuilders. And these are interesting cases to me because they came out the different way. So the first case, the Tucson case about the lizard, the question was if the action that was going to be impact the lizard could be approved by the department. The question before the district court was whether or not the lizard would persist even if basically the Tucson lizard was in essence wiped out. Would you still have the sufficient flat-tailed horned lizard population, and therefore it wouldn't be threatened because it would survive in other areas? And Judge Tashima wrote a very thoughtful opinion saying that the agency, reversing the district court which had approved the action of the agency said this lizard is no longer needs to be protected because it will persist. And Judge Tashima said, you're relying on ambiguous studies, there is not sufficient support for what you did. A number of years earlier, that case was in 2009. In 2003, there's a case, National Association of Homebuilders versus Norton. That one was about the Arizona pygmy owl. And that case was a homebuilders challenge because the Fish and Wildlife Service had designated the pygmy owl as threatened under the Endangered Species Act, which would give it protections. And the homebuilders said there's no support for that. The issue there was a little different under the Endangered Species Act, was whether the Arizona pygmy owl was distinct from other pygmy owls. And if you want to read this opinion, you will find out a lengthy discussion of how the Arizona pygmy owl is different from the other pygmy owls and whether or not it is distinct. And I assume the law clerks had a lot of fun with Judge Tashima out here learning about the pygmy owl. But ultimately, Judge Tashima ruled and reversed in favor of the homebuilders, saying that the agency did not explain its reasoning sufficiently before it determined that, in fact, it was a distinct population and needed to be protected, so it reversed. And both those cases, to me, are interesting because they go to the subject of today's conference, which is the rule of law. And because in both cases, the idea was you have these important and strong protections in the Endangered Species Act, and Congress intended to protect the species, and you often have environmental groups, people who live in communities who want to protect the species, but the bottom line is you have to follow the rules. And the rules make very clear when a species can be protected, the factual findings the agency has to set out before it protects it. And in one case they had done it, and the other case they had not. Two other cases I want to talk about also I find very interesting, both of which were rulings in favor of the industry. So one is a case that's dear to my heart because it reminds me of my days when I was at NRDC, Conservation Northwest versus Sherman, which is a 2013 case. That's about the National Forest Plan, and what had happened is the environmentalists had sued the BLM, the Bureau of Land Management, over the National Forest Plan. And the BLM had eliminated a program called Survey and Manage for the forests. And in doing so, it got sued by the environmentalists who said that it had not properly gone through the rulemaking procedure before it eliminated what the environmentalists thought was this important program for land management. They won on summary judgment, but the district court did not give any remedy, and that caused there to be settlement negotiations between the agencies and the environmental groups. Ultimately, they settled, and the settlement was that the Survey and Manage program would remain, would not be eliminated, but it would be modified. So that went to the district court for approval. The district court approved it in a consent decree over the lumber company's objections. So the lumber company said, you can't do this, you have to go through rulemaking. District court approves it, lumber companies appeal. Judge Tashima wrote for the panel, striking down the consent decree on the grounds that it had not been had not gone through the rulemaking process. So that superficially is a win for the lumber companies, but if you step back from it, it's a win for the rule of law, and it's a win for the process, because frankly in that case, during that era, it was a consent decree that was favoring the environmental groups because they got their Survey and Manage program back. But by not going through the rulemaking, that means prospectively, including today, anytime the agency gets sued or wants to reach a settlement agreement with an industry, It may be the environmental group in one case, it could be the Petroleum Association in another case. It can reach a settlement agreement and not go through the rulemaking process and basically have a sweetheart deal. So that principle that was set out by Judge Tashima in that case was an important one, and the law has evolved since then. It's very interesting, but that was in the doctrine a particularly important one because it was saying if you had to go through the rulemaking process in the first place, just because you settle doesn't mean you get out of it. There obviously are many other settlements you don't have to go through the rulemaking process. So another case for the industry, one of my frequent opponents when I was at NRDC, and before that I was with the Attorney General's office, Western States Petroleum Association versus EPA. So this dates back a bit. This is going back to 1996. But this case is really interesting also because what had happened is the state of Washington, this is under the Clean Air Act. So under the Clean Air Act, at the time, the state proposed plans for permitting its stationary sources of emissions. So that could be a power plant, it could be a refinery, various industries would have to get permits. And in the permitting system, it could exempt an insignificant emission unit. And Washington State had proposed to exempt a number of emitters it called insignificant in its plan. At the time, Bill Clinton was president, Carol Browner was the head of US EPA, and EPA said, no, we won't approve the state of Washington's plan. We don't want you exempting these emitters. And WSPA, the Western States Petroleum Association, sued saying the last 8 plans before 8 different states were approved by EPA. We can't now say no to the state of Washington. EPA said, which I found entertaining, discussed in Judge Tashima's opinion, that the answer from EPA was, well, we didn't have a reasoned decision before, and this time it was reasoned and we thought about it, so you should approve it this time. Judge Tashima said no, said basically if you approve the last 8, then unless you have a very well-reasoned and articulated reason for denying number 9, you cannot do that. So he reversed EPA's ruling and sent it back to the drawing board. Again, the rule of law. I mean, I'm sure environmentalists were unhappy that now the so-called insignificant sources that obviously the state of Washington thought were not so insignificant could emit and were not subject to the permitting program. But the point is, US EPA, it may believe that it was right on the substance, but it had to go through the procedure. And for those who are in environmental law, or really any substantive area, the requirement that agencies go through the proper procedures before they make a decision, whether you are in a conservative or a more progressive administration, is very important. And having the court out there, both the district court and then the Court of Appeal, to say and to hold the agency's feet to the fire and say you need to comply with the law regardless of what the outcome is. And that's, for me, an important issue today, because if you look around and you see both judges where it appears that their rulings are ideological, or you have people challenging judges on the basis they believe because of who they were appointed, they are ideological. The whole rule of law and our justice system is at risk. So lastly, I have one more case. I'm not sure this fits the theme, but I really enjoyed reading the case, so I'm going to have to talk about it. It is California Trucking Association versus Sue, which is a 2018 case. That's an interesting case. It's actually a labor law case, but it's a case of interest to the environmental community because it involves the trucking industry, thus the California Trucking Association, at the court. And the question was whether the California Labor Commissioner could decide whether or not truck drivers for the trucking companies were employees of the trucking companies or independent contractors applying California law, or whether it was preempted by federal law. And there's federal law that deregulates the trucking industry and other interstate industries, and the district court had dismissed the lawsuit. So the Trucking Association sued, saying the Labor Commissioner was wrong, it was preempted by federal law, and basically the California Labor Commissioner could not decide. This was significant for the labor laws because the issue was the issue of whether a worker is an employee or an independent contractor is a key issue in the labor field and the environmental field, but in the labor field because if the truck driver is an independent contractor, there's no requirements for minimum wage, there's no requirement for meal and rest breaks, for paying overtime. All the protections to workers wouldn't apply if they're independent contractors. And most of the truck drivers at the port have been categorized historically as independent contractors. So this, in this case, Judge Tashima wrote for the court and said that the labor commissioner gets to decide in California whether or not the drivers are independent contractors or employees, and it is not preempted by federal law because you're talking about a welfare and safety law and not about what the intent was of the federal statute, which was to deregulate the market and to allow the market to decide routes, prices, and services, but it was not to preempt health and safety laws. That case is of particular interest to me because a lot of the work I did before I left NRDC involved the trucking industry, among others, at the port. And one of the things the environmental community is trying to do, and the governmental agencies, is to regulate the amount of emissions you can have from trucks. It's much harder to regulate if you have independent contractors, meaning Joe owns a truck and drives his truck around. It's much harder to regulate how clean his truck is. If you have a trucking company with employees, you can say to the trucking company, you have to have cleaner trucks. So I know the environmental groups have been watching that case, and there's now a fair amount of litigation, follow-up litigation, which is what happens next. Are they independent contractors or not? But the point of that decision that I read with interest, sitting in my neutral bench currently, but I read with interest, was what Judge Tashima had written. What's the bottom line? I think I have to say, as I was reading all of these opinions from Judge Tashima, it continued my admiration for him, and he continues to be my role model, because in reading these, and I've talked about more cases that resulted in favoring ultimately the industry, but the real winner was the rule of law, and that's what's important and makes our society function. And in each of the cases, they were extremely well written and thoughtful, and I encourage you, if you want to learn more about the flat-tailed horned lizard, it's a fascinating read. So is the Keynote. So I am grateful, and thank you for having me.
Hi everyone, I'm Kaipo Matsumura, and in contrast to the previous approach, which was very encyclopedic, I'm taking a deep dive into a single landmark decision that's of personal interest to me. So this talk is called Transcending Time and Place, Judge A. Wallace Tashima and LGBT Identity. So when I started here as a student at UCLA Law, the Williams Project, UCLA's sexual orientation law think tank, was only a few years old. Williams Project students buzzed with excitement about California's recently enacted Domestic Partnership Act, Mayor Gavin Newsom's failed attempt to issue marriage licenses to same-sex couples, and the marriage equality cases making their way up the various state courts. Defeats followed victories, but they failed to dampen the generally heady mood. And this was the context in which I first discovered Hernandez-Montiel versus INS, an opinion authored by Judge Toshima several years earlier. And if there's a clerk who worked on that case, I'd love to meet you. So at the time of Hernandez-Montiel, courts frequently accepted the argument that gay and lesbian identity was coextensive with sodomy and was therefore properly subject to condemnation. For example, in his dissenting opinion in Romer versus Evans, Justice Scalia argued that if it is rational under Bowers to criminalize the conduct, surely it is rational to deny special favor and protection to those with a self-avowed tendency or desire to engage in the conduct, just as it would be rational not to hire methadone users as bus drivers, even though some methadone users pose no threat to passenger safety. In response, many gay rights advocates began to embrace the argument that sexual orientation was biologically determined and therefore immutable. The allure of the immutability argument was obvious. If science could establish homosexuality as an inborn trait, laws discriminating on that basis would seem exceptionally cruel and unjustified, the punishment of status. But immutability is a double-edged sword. Scientists had long searched for homosexuality's biological basis to cure it, like many other undesirable traits. Being unable to change something might make it less morally blameworthy, but no more acceptable. Moreover, immutability discounts the role of choice in constituting one's identity. Even if sexual orientation is determined to a great degree, much of what makes it ethically relevant, whether to engage in intimate conduct, enter into same-sex relationships, publicly represent oneself as gay or lesbian, falls within the power of the individual to choose. Hernandez-Montiel managed to deliver on the promise of immutability without imposing these costs. The case centered on whether gay men with female sexual identities constituted a particular social group for purposes of asylum and withholding of deportation. At the time, the BIA defined a particular social group as a group of persons, all of whom share a common immutable characteristic. The BIA further clarified that whatever the common characteristic that defines the group, it must be one that the members of the group either cannot change or should not be required to change because it is fundamental to their individual identities or consciences. Through a little sleight of hand, Judge Tashima performed some magic. Replacing the disjunctive or with a semicolon, his opinion declared, "Sexual orientation and sexual identity are immutable. They are so fundamental to one's identity that a person should not be required to abandon them." Under this formulation, the second independent clause explains the first. Immutability is grounded not in biological difference, but in the moral imperative that the state protect decisions central to personhood. So needless to say, LGBT rights advocates gravitated to this statement within and outside of the immigration context. Hernandez-Montiel became a must-read case among the Williams Project students and impressionable young students like myself, wondering whether we should come out to our classmates and professors, and wondering about our futures in the legal profession, felt empowered by the clarity of the court's holding. In the intervening decade and a half, however, even this version of immutability, what some have called the new or soft immutability, has become the subject of scholarly criticism in ways that invite a critical re-examination of the Hernandez-Montiel decision. The focus on the centrality of a particular trait to one's identity still invites courts to make judgments about what traits are worthy of protection. In arguing for recognition, claimants must still shoehorn their life experiences into essentialized categories that may oversimplify their experiences. The inquiry continues to draw a distinction between favored and disfavored identities, stigmatizing those on the wrong side of the line. Moreover, our understandings of LGBT identity have changed in recent years, pushed to a large extent by a younger generation, even more suspicious of formal categories. So for these reasons, I admit to feeling some trepidation about how the Hernandez-Montiel opinion would hold up nearly 2 decades after it was written and a decade after I had last confronted it in this more woke, post-Obergefell, Me Too world. So although it successfully sidestepped some of the pitfalls of the old immutability, could it also avoid these newer immutability traps or identity traps I just described? Well, of course, it turns out that I needed to have been concerned. The social and scholarly developments of the last 18 years only emphasize how progressive the opinion was when it was written. In the remainder of this talk, I will examine how Judge Tashima succeeded in operationalizing Giovanni Hernandez-Montiel's identity-based claim while largely liberating him from the confines of fixed categories. So first, he entrusts Giovanni with control of his narrative. The factual background section of the opinion begins with 2 words, Giovanni testified. and it quickly becomes apparent that we will learn about Giovanni through a largely unfiltered retelling of his own experiences. Giovanni tells us that he was attracted to males by age 8, and that by age 12 he began to dress and behave as a woman. Our developing understanding of Giovanni's identity comes from witnessing the way he is treated by others. A father of a schoolmate threatens to kill him for perverting his son. He and other boys, also perceived to be gay, are told by the police that it is illegal for homosexuals to walk down the street and for men to dress like women. While walking down the street as a 14-year-old, he is grabbed by a police officer, thrown into the car, and driven to an uninhabited area where the officer demands that Giovanni take off his clothing and perform oral sex on him. Judge Tashima relates these events without labeling Giovanni's identity. It is not until Giovanni is placed in the treatment program where staff cut his hair and nails and force him to stop taking female hormones that Giovanni is described as having a gay sexual orientation, and then only to make the point that he was not cured despite his change in appearance. So second, resisting essentialist understandings of identity. Asylum seekers must identify a particular social group and demonstrate a well-founded fear of future persecution based on membership in that particular social group. These tasks depend on the conclusion that traits like sexual orientation or gender identity are essential ones. Judge Tashima plays along, but in doing so, he avoids essentializing based on biology and develops a view that treats identity as the effects of individual choices, actions, and public perceptions. So consider the two pieces of support he provides for the holding that sexual orientation is fundamental to a person's identity. First, he defines sexual orientation in opposition to the forced conversion of gays and lesbians, citing the American Psychiatric Association's condemnation of such therapies as unethical. Second, he notes that both the American Psychiatric Association and the American Psychological Association have removed homosexuality from their lists of mental disorders. So rather than defining sexual orientation by its inherent content, Judge Tashima defines it by what it is not. It is not something that should be changed or stigmatized. Third, embracing contextuality. So relatedly, Judge Tashima recognizes that signifiers of identity are context dependent. When used to perform his identity, Giovanni's hair and nails hold tremendous power. Giovanni was sexually assaulted because of these outward manifestations of his sexual orientation. But paradoxically, those features do not define him. After his conversion therapy, he says, "I was the same, and the only thing that had changed was the fact that they had cut my hair and cut my nails." Moreover, long hair and fingernails lose their meaning when taken outside the proper context. Judge Tashima observes that, quote, "The police were not going after people with long hair and nails, or everyone dressed in female clothing. Of course, police were not systematically targeting anyone, i.e. women, just because they walked down the street with those features." The opinion also displays a tremendous degree of modesty regarding the different cultural context in which Giovanni's claim arose. We know that Giovanni wore his hair long, grew out his fingernails, and took female hormones. Even around the time the case was decided, commentators assumed that Giovanni was transgender. But it is important to keep in mind that identity is culturally contingent. The gay rights movement in the US has largely succeeded in supplanting a conduct-based view of identity with an identity-based view coalescing around categories such as gay, lesbian, transgender, with inherent meaning. Yet other cultures organize identities differently, for instance, based less on same-sex attraction than on gender transgression. By protecting the interrelationship between Giovanni's own account of his sexual orientation and gender expression, Judge Tashima created a more inclusive, less rigid category that included gender expression as but one aspect of a more complex identity. And importantly, he freed asylum seekers from having to define their identities based on American social categories. To label Giovanni as transgender would be to impose a certain understanding of identity that might not match his own. So in describing the prosecutions of American citizens of Japanese descent for refusing to enlist while incarcerated in internment camps, Judge Tashima noted that most trials were presided over by federal district judges who had internalized the racism of the times. One of those judges had earlier proposed solving the nation's Jap problem by sending them all back to Japan and then sinking the island. But a handful of judges, like Judge Louis E. Goodman, demurred. In quashing an indictment, Judge Goodman declared, quote, "It is shocking to the conscience that an American citizen be confined on the ground of disloyalty, and then, while so under duress and restraint, be compelled to serve in the armed forces." In describing these cases, Judge Tashima observed that it is to their credit that a few judges rose above their time and place to see the strict and harsh application of the criminal sanctions to these young men. The image of transcending time and place aptly describes both the Hernandez-Montiel decision and the conception of identity contained therein. Speaking at the time, Shannon Minter, a lawyer for the National Center for Lesbian Rights, said, quote, "This is a groundbreaking decision. It is the first time a federal court has affirmed that persecution on the basis of sexual orientation is a basis for receiving asylum under U.S. law. For the reasons I've been describing, the opinion's conception of identity has also aged remarkably well. The declaration that sexual orientation and sexual identity are immutable, they are so fundamental to one's identity that a person should not be required to abandon them, continues to fuel efforts to fight discrimination. For instance, President Trump's proposed ban on transgender individuals serving in the military. As Shannon Minter just remarked to me last month, Judge Tashima's analysis has yet to be improved upon. Within the rigid strictures of the law, the Hernandez-Montiel opinion opens maximum space to recognize an identity that is the product of ongoing self-definition. It is an identity that the individual retains the power to change even while commanding the government's respect. To be clear, I cannot claim that Judge Tashima intended to embrace a performative theory of identity in Hernandez-Montiel, and I'm not even sure that he would agree with my characterizations of the opinion. Even if he were to agree, he might lay credit on the party's briefing, or legal arguments he inherited from previous opinions, or maybe the individual and victim-focused nature of asylum claims themselves. But I feel confident that most judges would not, either by design or instinct, have respected Giovanni's personal experiences to such a great extent. As a member of a community confined by the US government without due process on the basis of race and ethnicity, and as a Japanese American lawyer entering the legal profession during a less racially diverse time, Judge Tashima experienced firsthand how external perceptions of identity could translate to unequal treatment. Yet he also appreciates how nuanced those experiences could be, and we've heard a little bit about this. Having grown up in the middle of Los Angeles, for instance, he did not have the same opportunities to swim and fish as he did at the internment camp on the Colorado River Indian Reservation. Although he knew there was something strange and disturbing about the situation as a child, his understanding of the experience developed over the course of many years. Likewise, he was appointed to the district court by a president, Jimmy Carter, committed to diversifying the federal bench. It stands to reason that someone with these experiences would understand the multifaceted nature of identity categories and the ways in which those identities intersect with the law. In his characteristically understated way, Judge Tashima admits as much. In a keynote address presented at a conference regarding the Japanese American civil liberties cases of World War II, Judge Tashima said, "I have no doubt that my life experiences, including the evacuation and internment, have shaped the way I view my job as a federal judge." In that essay, he shares this brief digression. My fifth grade teacher, and this is very characteristic, my fifth grade teacher was Miss Sato. Incidentally, I learned many years later that Miss Sato and my fourth grade teacher, Miss Omori, were paid $19 per month for their professional labors, but that my third grade teacher, Miss Satterwhite, who was white, was paid $150 per month. The essay continues on with no further mention of Miss Sato. The facts speak for themselves here. They require no further explanation and are given none. What he describes as incidental turns out to be the whole point. In Hernandez Montiel, the facts also speak for themselves. Truth emerges in the spaces in between. In the process, a person's humanity and security are preserved. Thank you, Judge Tashima, for speaking truth to power in your own inevitable way.
Thank you to everyone who has worked so hard to bring this conference together and make it happen. I'd also like to say thank you to Judge Tashima for allowing us to embark on this joyful and reflective endeavor here today. So preparing for this panel brought me to reflect on how the clerkship shaped me. And one of those ways was that it gave me one of my key, if one of very few snippets of wisdom that I can share with other young people who are starting on their path in the law. So when applying to clerkships long ago, one of the ways in which I made a list was to not include any judge, no matter their other virtues, who had a reputation for mistreating their clerks. And we have all heard those stories. So subsequent events have borne out the wisdom of that choice. And most strongly in that it led me, for me, the significance was that it led me to work for a man who was worthy of such deep respect due to his dignity and integrity, and the respect that he paid to those around him. So the advice I give to others is simply that working for someone whose work and character you admire is one of the primary ways to grow and flourish as a young lawyer, or indeed at any stage in life. So turning now to the question of Judge Tashima's jurisprudence, when I came to this talk, I also decided to look back and look into Westlaw to think about Judge Tashima's decisions. And to take an empirical slice. I did this by basically sorting by his most heavily cited opinions and reading some of them, poring over them, and looking for what I found there. And what I found that struck me as a common core, a unifying thread, I think will not surprise those who are here today. That was a total allegiance to procedural justice. Federal judges don't get to be radicals. They don't have the luxury of dedicating themselves to causes or to singular viewpoints, no matter how sympathetic they might find them. But the singular cause of the federal courts is in fact procedural justice. Not always at all costs, but even when balanced among competing concerns, the value of due process is paramount. And so as I read Judge Tashima's opinions, that dedication to procedural fairness struck me again and again, to basic elements like notice and a meaningful opportunity to be heard. And those threads surfaced most obviously across three types of cases, those of pro se prisoners, immigrants, and civil rights litigants. So among the most vulnerable people in our society, and certainly those who face some of the greatest barriers to accessing justice. And in another brief personal digression, I, as a new law professor, taught civil procedure to my first group of law students this past fall. So I chose to take what is a minority approach, though a staunchly supported one among civil procedure faculty, and I began the course with an initial unit on procedural due process and access to justice as an introduction to some of the big picture themes and questions that underlie the sometimes technical rules of civil procedure. So some of my students, of course, wondered why they weren't starting with Penoyer v. Neff. But nonetheless, I think it was successful overall, and that it raised for students the most important questions, some of the ones that brought them to law school. How do we assure equal access to justice? How do we have rule of law on the terms that are most equitable to all? So it was doubly meaningful to me to come back to Judge Tashima's decisions and see those threads there. And I found one of the most noticeable aspects of Judge Tashima's jurisprudence is that he is most demanding of courts themselves and of the institutions that intersect with them in the justice system. The demand is that these institutional actors live up to their ideals of meaningful and equitable process, and he does so while acknowledging the practical difficulties, the real world difficulties that those caught up in legal proceedings face in navigating those procedures. That demand sounds in rule of law values, in democratic values, and in concern for the most vulnerable among us. And it's simultaneously deeply respectful of the institutional boundaries and limits of the federal judiciary in our system of governance. So let me give you some examples of Judge Tashima's jurisprudence in those three areas that I've mentioned. So beginning with pro se prisoners. One of Judge Tashima's most heavily cited opinions came in an en banc case involving pro se prisoners' right to fair notice of the standards for summary judgment, Rand v. Rowland. It has been cited almost 4,000 times in other cases. The principle that Judge Tashima announces is simple. It is simply a rule that prisoners facing motions for summary judgment against them be told in ordinary, understandable language, those are his words, of the consequences of failing to respond to a motion for summary judgment. The rule didn't initially originate in this decision, but Judge Tashima reaffirmed it there, citing the vulnerabilities of pro se litigants generally and the special obstacles faced by those who are incarcerated. As he wrote, affirmative measures are sometimes required to ensure that a prisoner's access to the courts is adequate, effective, and meaningful. In another case, in 2006, involving a California state prisoner seeking habeas review, Mendoza v. Carey, Judge Tashima wrote for the panel in ruling that the prisoner's lack of access to Spanish language law books or translators could actually entitle him to equitable tolling of the 1-year filing deadline under federal law, under the Anti-Terrorism and Effective Death Penalty Act. And so the decision rested on the logical ground that a prisoner's actual inability to learn of the 1-year time limit would in fact constitute extraordinary circumstances sufficient to toll this limitations period. Mendoza has been cited nearly 1,000 times in case law. In another instance, in 2001, in a case captioned Herbst v. Cook, Judge Tashima wrote for a panel ruling that a district court erred in sua sponte dismissing a habeas petition on statute of limitation grounds without giving the prisoner adequate notice or an opportunity to respond. Judge Tashima soundly rejected the argument that a motion for reconsideration might somehow serve the purpose of an actual initial opportunity to respond on the merits, noting, among other things, that the legal threshold was higher and that the standard of review was more deferential for such motions. Herbst has been cited nearly 1,500 times in case law. Turning now to immigrants, several of Judge Tashima's most often relied upon decisions enforce similar guarantees of procedural justice for immigrants. In a case involving Carlos Humberto Ordonez, Judge Tashima enforced the statutory requirement that immigrants receive fair notice of the consequences of failing to comply with a voluntary departure order. The judge wrote incisively of the need for such notice. Quote, "An alien may have little education and even less experience dealing with the legal system. He or she may also incorrectly assume that while appeals are pending, the alien will not be required to depart." In another case involving Nicolas Rodriguez Lares and his wife, Maria Guevara Martinez, Judge Tashima again emphasized procedural fairness. Defrauded by an immigration consultant and lawyers who failed to timely file papers on their behalf and lied to them about it subsequently, this couple sought to reopen their deportation proceedings. Judge Tashima wrote for the panel that they were entitled to equitable tolling and had suffered a due process violation given the ineffective assistance of their counsel. In another case involving Juan Manuel Mora Inclán, however, Judge Tashima was forced to dissent. The panel on which she was on concluded that although the immigrant had shown a due process violation in his deportation hearings, in that the judges failed to the immigration judges had failed to give him notice that he might be eligible for relief from deportation, the panel ruled that the litigant had failed to show that the violation resulted in any prejudice. Judge Tashima wrote movingly of the showing Mora Inclán had made as to the hardship that would result for his U.S. citizen wife and 3 children who would grow up without him were he to be deported. Finally, turning to the civil rights cases, two other heavily cited opinions of Judge Tashima's emphasized procedural fairness in Title VII employment discrimination cases. In an early decision from the 1980s involving a firefighter suing the San Francisco Fire Department for race discrimination, Garrett v. City and County of San Francisco, the lower court had refused to entertain the plaintiff's motion for further discovery, instead deeming it moot after granting a summary judgment against him. Judge Tashima pointed out that the type of evidence the plaintiff lacked at the summary judgment stage was precisely the type of evidence that plaintiff's motion to compel sought to elicit, i.e. evidence of disparate treatment vis-a-vis white firefighters. And so he reversed the lower court so that Garrett might have a fair chance to seek that evidence. In another Title VII case, in 2000, Association of Mexican American Educators versus State of California, Judge Tashima actually dissented from an en banc Ninth Circuit. He argued that the lower court had engaged a technical advisor on testing without appropriate transparency and procedural protections for the parties. The plaintiffs had argued that this advisor actually had deep ties to the defendants in the case. In his dissent, Judge Tashima argued that the Ninth Circuit actually lacked clear guidelines for the engagement of such advisors, and he proposed some very concrete ones, which included a fair and open procedure for such appointments, a means of challenging and addressing potential bias on the part of the advisor, clear parameters for the advisor's work, and a means to make the advisor's work's nature and content clear for the parties and for appellate review. Otherwise, he argued, quote, concealing the nature of the expert advice can only erode confidence in the court's role as a neutral and independent decision maker. And although Judge Tashima wrote in dissent in that decision, the Federal Circuit officially adopted Judge Tashima's suggestions in 2002, and they have proved highly influential across the federal courts, including the Ninth Circuit. So not all of the opinions that I've mentioned might be as fundamental in that dissent in their attempt to reshape a particular area of law. But the fact that they enforce such baseline components of fair process and as a result become so heavily cited suggests to me their impact. Such opinions and judges like Judge Tashima have a cumulative impact. They attempt to ensure that the promise of equal justice under law and of meaningful access to justice is reinforced in an ongoing, day in, day out kind of way, from small to large principles that can actually make the legal process a real one, rather than a facade and a trap for the unwary. In a time when we see so many fundamentals of our justice system under attack, our institutions and values drawn into question, it is hard to overstate the impact of such rulings and such judges. Thank you.
Thank you all. It's amazing for me to be able to follow on the heels of all those wonderful presentations. It provokes 2 thoughts that I wanted to start with. One is just echoing in my mind throughout all of the discussions so far has been the Dean's phrase of protecting the rule of law blended with empathy for the less advantaged and those with less power in our society. And I think that that theme shines really clearly through all the presentations that we've heard. I also wanted to say that listening to everyone made me feel both very lucky and unlucky in ways that I want to describe. I felt very lucky listening to Dean Dodek, because I think while he got the short end of the stick with respect to travel, our class here got a really great opportunity, because we ended up having to travel to Hawaii and having a co-clerk whose uncle was a rock music promoter and was able to get us a mad discount in the Royal Hawaiian Hotel, where we stayed, all of us, for a week and had an amazing time. So I'm sorry that we had that. It also made me recall the fact that I traveled up to Portland, Oregon on September the 10th, 2001, to meet the judge for oral argument in Portland. And the next day woke up to tragedy, but out of that tragedy was born the opportunity to spend a week with the judge in Portland, where we got to process what had happened, which was very profound for me, but I also got to learn a lot about who the judge was as a man, and that has sort of stayed with me as a very indelible imprint of the time I had clerking with him. The unlucky part of following everybody is that Justice Feurer's comments are going to overlap a little bit with mine and intersect around this case of the California Trucking Association versus Sue. I'm hoping that it'll be more illuminating than redundant, but I'm going to ask your indulgence of bearing with me with respect to some repetition. I'm going to focus on the labor aspect and not the environmental aspect. So, and I'm going to focus on sort of the Professor Matsumura model of a deep dive into the case and the background of the case, as opposed to kind of looking across different cases. So I'm hoping that this will be kind of a way of deepening the discussion that has already been started. So I'm going to talk about the importance of Judge Tashima's take on a critically important statute. So I want to start with the statute that almost no one has heard about, but ends up having a really important impact on the labor rights of some of the most vulnerable workers in this city and this state. And the statute is the confusingly and cumbersomely named Federal Aviation Administration Authorization Act of 1994. So yes, it's a mouthful, and thus it's clear why the name is cumbersome. I will refer to it as the F-Quad-A going forward, as it's lovingly called. Why is the F-Quad-A confusing? Because despite the aviation in the name of the statute contains an important and hotly contested provision that preempts state and local laws that relate to trucking. So now is where you might ask, why should I care about that? This is a question that I asked myself several years ago when I first encountered the F-Quad-A. And preemption is, after all, the sort of highly esoteric area of law reserved to con law jocks and Fed court jocks, not those of us who study the legal profession and economic development. But preemption is also an issue that has increasingly important impacts on labor and consumer rights, as those of you who have followed the jurisprudence on the Federal Arbitration Act will know. And as it turns out, the F-Quad-A itself is a statute that has been at the center of a growing debate about labor standards in the trucking industry, with the key issue being whether or not truck drivers should be treated as statutory employees of trucking firms with all the rights and protections that that entails, or whether trucking firms should be permitted to treat their drivers as independent contractors, essentially owner-operators of their businesses who must carry their own costs and who are not entitled to minimum wage, overtime, and other employment rights, and who are crucially precluded from organizing unions under federal antitrust law. Why should we care about truck drivers? There are two reasons, I think, that are important to highlight. One is that these are the workers who make our consumer economy go round. They're central links in the global supply chain, who help haul roughly $500 billion of imported cargo from the ports each year to warehouses and retail outlets like Walmart and Target, and who carry those little cardboard boxes from Amazon and other online stores right to our doorsteps. The other reason I think we should care is that truck drivers are the bellwethers of change in our economy, mostly treated as frontline gig workers to whom companies have shifted risk in order to reap reward. They are, in other words, visible symbols of our nation's growing inequality, men mostly, who are often invisible to us in our day-to-day lives, but if you look around, if you pay attention on the freeways, you will see them, solitary figures transporting those hulking containers that feed our consumption. So my comments here on the F-Quad-A preemption and labor rights arise at the intersection of my research into port trucking my teaching and the opportunity afforded by this conference to reflect on Judge Tashima's jurisprudence. I started working on this conference without intending to write anything, but a series of really happy coincidences sort of led me to do it and to make me understand why it was important to do so. The first piece of coincidence was that I wrote a book on the role of law in the campaign to raise labor and environmental standards in port trucking, which was published last year, and in which Justice Feuer plays an incredibly important role, which she overly humbly described. She actually brought an incredibly important lawsuit that essentially shut down development at the Port of Los Angeles until it decided to clean up its act and clean up the air that it was polluting, both through a lot of machines on the ground, but importantly through the way that it treated trucks. The book is fundamentally about how laws contributed to the conversion of the trucking industry from one of the most heavily unionized in the nation to one now defined by labor precarity. But it's also how law has been used as a tool to sort of raise economic and environmental standards at the ports, which have also been, again, one of the largest sources of pollution in the region. In the book, federal preemption hovers over the entire story, which is essentially about what people do at the local level to protect their rights when the government at the federal level has seemed to advocate its role. So through the project, I became intrigued in the role of preemption generally and F-Quad A preemption in particular in shaping the legal environment of labor rights mobilization. In the book, I touch upon, but do not go into detail in any deep sense, into the variety of ways in which the trucking industry had used the doctrine of federal preemption to try to insulate its independent contracting practices from state employment law scrutiny. I knew this was a really important topic, and someone should write about it, but it was outside the scope of my project. The second event that propelled this project forward was that I taught a course last term in which I worked with a team of really amazing students, including one of the editors of the Law Review, who was responsible for the conference. And we drafted a legal opinion seeking to understand, among other things, how federal preemption might affect the rollout of a new California state law called SB 1402, which was passed last year and imposes joint liability on customers of port trucking firms, mostly shippers and retailers, when they contract with port trucking firms that have outstanding unpaid wage claim judgments against them. So we drafted that opinion. I was very happy to stop there, but then this conference started to unfold. And in working on the project, I came across the most recent and important decision, which Justice Feuer has already alluded to, which is on F-Quad A preemption. And I was pleasantly surprised to see that it had been authored by none other than the Honorable A. Wallace Tashima, with Judge Nguyen actually signing on to that opinion. And so I decided that there was this unique opportunity to synthesize the context on port trucking, the analysis of F-Quad A preemption law, and the Toshima opinion, in this case, California Trucking Association versus Sue, which was decided last September. I'd like to use that opinion to say something about the current state of preemption in the trucking industry and why I think it's important. So let me start by saying a little bit more about this strange little statute, the F-Quad A. It was passed in 1994. It was meant to solidify the deregulation of the trucking industry, which had started roughly 2 decades earlier and was codified in the Motor Carrier Act of 1980, which dismantled what had been sort of the systematic regulation of interstate trucking that had produced a trucking industry that in the 1970s was defined really by a few really large players, and all of those players were unionized. Deregulation led to the breaking up of a lot of these large carriers, which were replaced by much smaller, non-asset-based firms that had shed their labor force and instead contracted out to drivers responsible for acquiring and maintaining their own trucks. At the ports of Los Angeles and Long Beach, which are combined the biggest port complex in the United States and one of the biggest in the world, this contracting out had a huge impact on what they call short-haul drivers, who deliver cargo from the ships to regional warehouses, retail stores, and railheads. In 2000, there were roughly 16,000 such drivers. About 90% of them were classified as independent contractors. Nearly all of them were immigrant men, mostly from Mexico and Central America, and they earned on average, according to studies of their wage standards, roughly $10 an hour after you factored out all the costs that they had to carry as independent owner-operators. What the F-Quad A says is that there's nothing states or cities can do to interfere with trucking deregulation and its consequences, And specifically, it prohibits any state or locality from passing a law that's, quote, related to the price, route, or service of a motor carrier transporting property. So this statute, the F Quad A, sort of lived in the dark for about a decade, and then it was brought out of the shadows in the mid-2000s when truck drivers at the ports started contesting their classification as independent contractors. They started showing up at the California Labor Commission, which enforces state labor law, saying, although trucking firms put the label of independent contractor on us, in reality they control nearly everything we do, from what cargo we haul to when we pick it up, to the signage on our trucks. Some contracts with drivers even precluded them from working for any other company. So the claim that they were making was that the reality under the label was that port truck drivers were in effect low-wage workers deprived of a range of employment rights, from minimum wage to the right to be reimbursed for business expenses. They were, in short, misclassified. So this is where the F Quad A comes in, because in response to driver claims of misclassification, which is a predicate upon which they can claim labor rights, right, labor and employment rights, trucking firms began to argue F Quad A preemption. In effect, they start to claim that the state could not enforce its own labor law against them, because to do so would change the nature of their contractual relationships with drivers and raise their costs in ways that related to their price, routes, and services as motor carriers, and thus violating the deregulatory mandate of the F Quad A. So after some early precedents outside of port trucking, the issue of F Quad A preemption of misclassification claims gained prominence in the Ninth Circuit. So in 2011, the Ninth Circuit, in the case of American Trucking Associations versus the City of Los Angeles, the Ninth Circuit invalidated a key part of a local ordinance called the Clean Truck Program that required trucking firms at the ports to use employee drivers in an effort to essentially locally outlaw misclassification. The Ninth Circuit, in an opinion by Judge Betty Fletcher, held that that employee requirement targeted trucking firms in a way that related to their price, route, and service, and thus was in fact preempted by the F Quad A. That case actually went up to the Supreme Court on other grounds. This ATA case and the Ninth Circuit led more workers to take their individual misclassification claims to the Labor Commissioner, whose Division of Labor Standards Enforcement contains a wage claim process that permits individual workers to enforce basic employment rights against their employers. To do so requires a predicate finding that the workers are in fact statutory employees. So beginning in 2010, there was an explosion of these misclassification claims at the Labor Commissioner, such that by 2017, there had been over 800 filed. In I think every single one of them, the worker wins the case, and collectively they were able to collect $35 million in damages from trucking firms. So the trucking industry's response to this was pretty dramatic. The California Trucking Association, the state industry trade group, in 2016 filed a suit against then Labor Commissioner Julie Su, seeking an injunction forcing her office to stop adjudicating these misclassification claims on the ground that doing so in total was preempted by the F Quad A. So the lawsuit really struck at the heart of the state's ability to enforce its own labor standards against trucking firms by claiming that the commissioner's use of the state common law test for determining whether a driver was an employee, the Borrello standard, was preempted because it, quotes, disrupts the contractual arrangement between owner-operators and motor carriers, which introduces inefficiencies into the transportation services market and is inconsistent with Congress's deregulatory goals under the F Quad A. So the case is assigned to a 3-judge panel led by our very own Judge Tashima. And in a case that I want to suggest is one of the pivotal ones in F Quad A jurisprudence, Judge Tashima and Judge Wynn and Paez carefully delineate the boundaries of what kind of state laws are preempted, excluding from preemption what they call generally applicable laws in a traditional area of state regulation. So I want to just end by briefly saying what this means, what it doesn't mean, and why it's so important. The central question the case presents is whether or not the state can continue to be an arbiter of truck driver employment rights. So at its core, the trucking industry argues that the Labor Commissioner is precluded from overseeing compliance with labor rights because doing so would, quote, replace freely bargained, efficiency-driven contract terms voluntarily chosen by drivers with California's normative policy judgment about what those terms ought to be. With devastating precision, Judge Tashima reveals the specious nature of this claim. First, the opinion stresses the nature of the parties' unequal bargaining power, fundamentally calling into question the voluntariness with which port drivers enter into independent contractor agreements. Indeed, the notion that the application of the Borrello standard by the Labor Commissioner undermines the free market agreement between company and driver is directly contradicted by the brute fact that it's the drivers themselves who are bringing the misclassification claims in the first instance. If they believed those agreements were voluntary and just, they would of course have no cause to bring them in the first place. Second, and I think more importantly, the opinion shows how the industry's argument collapses under the weight of its own formalism. So at bottom, what the industry argues is that the state should be precluded from evaluating whether the label of independent contractor matches the reality of the way trucking firms treat drivers. If this were the case, there would be nothing to stop any trucking company from labeling all of its drivers as independent contractors and then controlling every aspect of their work just as if they were statutory employees and paying them in ways that violated state employment law. This, of course, would be an absurd and very dangerous result, one clearly not contemplated by the F Quad A, and which would eviscerate the minimal protections that truck drivers already have, consigning them to the status of second-class labor citizens. As the opinion stresses, there's nothing in the state's application of the Borrello standard that actually prevents trucking firms from engaging with drivers as independent contractors. They simply have to follow the standards for independent contractors set forth by law. They have to generally give drivers control of their work, which is the Borrello standard. If they're called to account by drivers for their treatment and practice, firms must be able to prove that they do not exercise employer-like control. And as the opinion concludes, the state has to be able to play that critical oversight and enforcement role. It has to be able to uphold the rule of law, or else no one will. So in the end, the case of California Trucking Association versus Sue constitutes, I think, a watershed moment in the development of a preemption doctrine that has broader implications for the future of work. Preserving the state's role in adjudicating the boundaries and content of employment and pushing back against the proliferation of contract jobs, Uber, Postmates, truck driving, a category of jobs which is growing faster than any other in the economy, is at the heart of a struggle over the definition and meaning of contemporary work. And what I admire most about Judge Tashima's opinion, and this is, I think, a point that echoes something that Kaipo said, is that it illuminates these points without really making them explicit. He takes this enormously convoluted area of law, synthesizes it with clarity and elegance, and then he shows why, without editorializing, right, that it can lead only to one conclusion, that Congress did not intend to foreclose states from applying common law tests to discern who is entitled to generally applicable labor protections, right? It makes that's the facts really speak for themselves. So in a system of deregulatory preemption like the F Quad A, where the goal is literally to eliminate sub-federal law touching on one industry, being able to define strict limits on that purported elimination is critical to preserving the relevance of basic background principles of labor protections for a class of workers who form the connective tissue of our consumer economy. So thank you, Judge Tashima, for drawing that line so powerfully, so elegantly. Again, the rule of law blended with empathy for the less vulnerable. Thank you. I'm going to step into my role as moderator, and just I think where we are in terms of time is good. We actually started 15 minutes early, so we can cut off a little bit earlier. But I do want to leave open a little bit of time and give opportunity to people to ask questions to the panelists or to the judge. So I will hold on people who don't ask questions. Any questions? Yeah.
Can I ask Judge Tashima what our takes on his jurisprudence?
Go ahead.
Did it ring true, what we came up with?
I'm still processing it. The thing that struck me most about all the presentation is you all kind of volunteered to do a lot of extra reading.
That was my other thought when I listened to Justice Feuer, was that she's much more diligent than I am, because she read all the cases in the area. Well, or at least I picked a better area because I only focused on only one case, and you got to read a lot, but that's good.
I read the same thing.
I know you read the same thing. Any other thoughts or questions? Do any of our panelists have any reflections? Oh, yeah, go ahead.
I'll put you on the spot again. You have to take what comes to you, but do you find that there are certain topics, certain subjects, case subjects, that you find yourself being more engaged with, or is it all the same?
No, it's not. The question I get all the time, it's not all the same. Strange as it may seem, I do like, and you mentioned it in this panel, I like the kind of odd civil procedure questions, which don't have a simple and clear answer. I spent a lot of time with that, but that may be almost like a diversion or a hobby, because
Yeah.
there are other subjects of interest, and without mentioning them, I sort of have a feel now, when I get assigned to a case that's not some important principle, like the CTA case, I tend to recognize that earlier now. So I do spend a little more time on those. But we do think, one of the great things though about being a federal judge, maybe more a trial judge than the trial judge, and Gail may find that out, is that, in the federal system, as you remember, you just take everything as it comes along.
Right.
You don't get to choose what you take, and so that's part of the fascination of the job, I think, is having to change directions on a dime.
Any questions? Thoughts? Yeah.
Are there any clerks who have something they might share from some of the cases that were referenced with greater color and detail, memories of working with the judge on that particular case?
Hi, I'm Wendy Levine. I clerked for Judge Tashima when he wrote the Hernandez-Montiel opinion, which I was assigned to. And I was, for me, it was like why I clerked, right? And I said to the judge, we could write this as an unpublished opinion and write it really narrow, but what do you think if we kind of go big? And he said, go for it. And that case came down, it was published right as administrations were changing, and the last day for the administration to have tried to get the case to the Supreme Court was the last day of the Clinton administration, and so we made it by a day. And there was no appeal of the decision.
One thing that struck me was, the effective communication and the opinions and the way they're written so artfully. So one question I have for the judge is, have you changed the way you think about how to write an opinion or your approach to writing opinions over time, or is it just kind of your natural preferred writing style?
I'm hesitating because that's a difficult question to answer. I notice clerks. Well, first of all, my usual, not invariable, but usual style is to have a law clerk, the law clerk who did the research for the bench memo, draft the initial disposition, especially if it's an opinion. I don't try and law clerks approach it differently. I don't try to, dictate to a law clerk how to draft the opinion. What's important, what's not important, what should be emphasized. Except once in a while, I might say something like, this after draft comes in, let's slide over that problem. but I really leave it to each clerk to fashion his or her own draft. Sometimes I edit a lot, sometimes I edit almost not at all. It's over the years, it's surprising to me now that there is as much uniformity, in my opinion, as there is, because they spring from so many different sources. What does that mean? Does that mean, in a sense, we all are driven by the same, instincts to write the same way? I haven't figured that one out, but my basic rule is, and I think my current clerks know this well, is, just take a crack at the first draft and let me see what it says. And it's not something I dictate. And I think it's better for the clerk in the development of their own writing style to be able to approach it that way.
Yes.
I have a question, I guess for the panel, and it may become a question for the judge. And I was one of the cut and paste era clerks. And at the time that Judge Tashima was appointed to the bench, well, prior to his practice was heavily in the antitrust area. And I was wondering whether any of the panelists thought about or looked at focusing on his work in that area. And I guess that would be the question for the panel, and then maybe the question for the judge is, given that that's where so much of your practice was, whether that's an area that you feel like you have had, or you've made an effort to have more of a contribution.
My panelist response is no. Concur.
You would think they might come up in the most heavily, but apparently antitrust is not in the thousands of citations. Take decisions that I looked at.
Hello, Chris. I will say this, I did do quite a bit of antitrust work as a lawyer. But in later years, after I became, I think when I was on the district court, antitrust cases were much more active than they are now. I think I tried maybe a number of pretty sizable antitrust cases, including several criminal cases. But over time, and Max Bleacher, who was one of the great plaintiffs lawyers, antitrust plaintiff lawyers in our state, not too long before he died, he complained bitterly how the practice of antitrust law has almost disappeared. Right? And I think you know that too, Chris, and that's partly because of the sort of change in enforcement style. I used to think it was mostly Republican, but it's really both parties now. They approach antitrust enforcement much more differently, and maybe it's much more tolerant of a more dominant enterprise or entity monopolizing an industry. So antitrust, I think it's not gone, but it's gone way down. So people I know who practice antitrust law, they've migrated to other areas. I think on both sides, plaintiffs and defense. So it's something. I guess if you're an old-time lawyer, you can mourn, but it doesn't. You can't do much more than that. But I do miss it.
And I'll actually take the liberty of following up with an anecdote about that I remember from my clerkship. It was, I don't remember the case by any means, but it was a case that presented antitrust issues, and you actually decided to write on it, I recall. And when we were discussing it and discussing some of the Ninth Circuit decisions that we were going to be discussing in the case, you made a comment to the effect of the Ninth Circuit didn't really understand antitrust law. But the Supreme Court got it right, so we had to look at those decisions rather than what the Ninth Circuit was doing at that time.
So I think that's a great anecdote to stop on. Well, for two reasons. One is because I want to keep the trains running on time, but the other one is because I do think, you know, as I've been reflecting on my own experiences with the judge, and I think as your anecdote suggests, that these moments with the judge really are so bright in our minds, and I think the opportunity to sort of keep remembering them and sharing them and talking about them is going to be the focal point of what we do throughout the rest of the day and after lunch. And so I think it's a nice segue into our lunch. So we have roughly an hour and 15 minutes. We're supposed to reconvene at 1:45. Lunch is out in the hallway. So I invite everyone to grab a box lunch, be where you'd like to be. You don't have to be in here. You can be out in the courtyard and enjoy each other's company. And we will see you at 1:45. And thank you to all our amazing panelists.
Good afternoon, everyone. I'm going to give an initial disclaimer, which is that I'm feeling a little bit under the weather, so I'm not feeling my usual perky self. So forgive me in that regard. But I am going to be talking about why Judge Tashima is so important to the Asian American legal community, and then also talk about his fidelity to the judge's oath and how important that is. I am a 1984 graduate of this wonderful law school. If I recall correctly, my class of over 300 people had 13 Asian American students, which was a bumper crop that year. As students, we were acutely aware of the fact that there were only 2 Asian American federal trial judges in the entire country, Robert M. Takasugi and A. Wallace Tashima. And for nearly 20 years, that remained true, except that Ronald Liu joined them in the middle of that period. And they were all located in one place, Los Angeles, the Central District of California. Let that sink in for a moment. 20 years. That was most of the time that I was a law student and a practicing attorney. And so, for that amount of time, these 3 judges were the face of the Asian American community on the federal trial bench in the entire nation. The question then is not whether Judge Tashima had an important impact on the Asian American legal community. It's how could he not? With his characteristic humility and modesty, I'm sure Judge Tashima probably never thought about or set about to become a legal icon or role model. He simply is. Any discussion about Judge Tashima's importance to the Asian American legal community cannot be divorced from the historical backdrop of World War II and the mass incarceration of over 120,000 Japanese Americans. Among them were 80,000 people who were American citizens. 30,000 of them were children, like Judge Tashima, who was incarcerated with his family at the concentration camp at Post in Arizona. Wartime hysteria, racial prejudice, and blatant lies, whipped up by politicians and the media, allowed the military to forcibly relocate an entire segment of the population who were not charged with any crime or were found to have been engaged in any disloyal acts of any kind. All of this done without even a semblance of due process protections. Executive Order 9066 was signed by FDR on February 19th, 1942,
just 2 months after the attack on Pearl Harbor. Talk about a rush to judgment. And then just 2 months after that, Japanese Americans were already being herded into assembly centers not fit for human habitation, and then moved to concentration camps on federal lands in remote and barren locations where they were incarcerated in terrible conditions from 1942 to 1945. This colossally egregious error of judgment, law, and policy was perpetrated by some of our most esteemed leaders in American history, including FDR and former California Attorney General Earl Warren. And the error was compounded by its acceptance in the courts on the basis of wartime military necessity, particularly by Supreme Court cases like U.S. versus Korematsu, which upheld the exclusion order. A famous civil libertarian, Justice William O. Douglas, joined the majority in that decision. We know now that the finding of military necessity rested on a lie that was furthered by the suppression of evidence. The Korematsu case has been called a stain on American jurisprudence, which it most undoubtedly was. Ironically, it was the first case to apply the strict scrutiny standard, and yet upheld racial discrimination in its most blatant and virulent form. Just imagine how marginalized and voiceless Japanese Americans were, that they could be equated as an entire group with enemy combatants solely on the basis of their ancestry, deprived of their liberty and property, and incarcerated en masse, men, women, and children, for nearly 3 years. It is against this backdrop of tragic history that we must understand how meaningful it was to have Judge Tashima appointed to the federal trial court, and then subsequently to the Ninth Circuit Federal Circuit Court, the same branch of government that so many years ago had failed to uphold the rights of a disfavored minority. Judge Tashima became a source of pride and hope for the community, that a person from so marginalized a group finally has a seat at the table, transforms an institution from the inside out, vindicates an entire community from an unjust judgment in history, and signifies acceptance and recognition that Japanese Americans are mainstream Americans. It also helps, of course, when that person is someone like Judge Tashima, a distinguished person of integrity who respects the rule of law and his oath as a judge. And that brings me to my next topic, which is Judge Tashima's fidelity to the rule of law and the judge's oath. Federal judges take an oath when they take the bench to administer justice without respect to persons, and to do equal right to the poor and to the rich, and to faithfully and impartially discharge and perform all the duties incumbent upon them under the Constitution and the laws of the United States. I think that most judges, I won't say all, but most judges take that oath very seriously and try their level best to apply the law to the facts in an impartial manner. That oath sets the judicial branch apart from the other two branches, which are the political branches. The oath of office of the U.S. President and that of the members of Congress does not require them to be impartial. That is a critically important distinction that I think is lost upon many members of the public and the media, who often equate us with the political branches. They have no conception of what the judicial decision-making process is. Those of you in the room who are judges who have been law clerks to judges know that we would not have to work nearly as hard as we do if all of us just sat around applying our personal opinions to our decisions. I find it exceedingly annoying whenever even seemingly favorable articles are written about me, for example, saying that I am a child of immigrants and that my decisions therefore have advocated for immigrants. The reality is that in my role, I advocate for nothing. I apply the law as it exists to the facts as I find them. By the same token, I'm sure that Judge Tashima has been characterized as a liberal judge because of his personal background. That type of lazy thinking feeds the false narrative that judges are merely an extension of the politics of the president who appointed them. To that extent, I think it was very important that Chief Justice John Roberts finally commented that we do not have Obama judges or Trump judges or Bush judges or Clinton judges. Of course, the media points to the one or two cases that they know about to validate their point, even though a judge may have decided thousands of cases, many of which don't fit that narrative at all. I'm reminded of one occasion when I was attending a conference in Nashville, and a law student at Vanderbilt Law School came up to me to introduce herself and tell me that she worked at a law firm that summer where her assignment was to research my wage and hour class certification orders to see if she could find a common trend or outcome. And I, of course, was very interested in what her findings was. And I said, and your conclusion was? And she said, my conclusion was that it depends. And I told her I thought that was an excellent conclusion. So I decided to test my thesis by looking at Judge Tashima's published federal civil rights cases to see if I could detect any common themes. I won't bore you with a recitation of all the cases I looked at. I looked at quite a few, but I will highlight just a few of them. In a 1990 case called Fuller versus Frank, when Judge Tashima was sitting by designation on the Ninth Circuit as a district judge, he affirmed a decision against a plaintiff, an admitted alcoholic who had brought suit under the Rehabilitation Act on the ground that the Postal Service had failed to accommodate his disability before terminating him. The Ninth Circuit, in Judge Tashima's decision, upheld the district court's decision that plaintiff's employer had provided reasonable accommodations after offering treatment to the plaintiff 3 times before a last chance warning that finally led to his termination. Despite plaintiff's argument that additional discovery would have prevented summary judgment, Judge Tashima pointed out that the plaintiff never requested additional discovery from the trial court. In a 2018 case called Nunes versus HIE Holdings, Inc., Judge Tashima wrote another decision in a ADA disability discrimination action in which he overturned a district court's dismissal of an ADA case on the ground that Hawaii had expanded its definition of what was regarded as disability or perceived disability. And in applying that new standard, there was a triable issue of fact as to whether the plaintiff had been terminated as a result of a perceived disability arising out of a shoulder injury. Looking at some of his equal protection cases, in 2002, in a case called Wittmeyer versus Arizona, Judge Tashima wrote a decision that reversed a trial court's dismissal of an Arizona state prisoner's equal protection claim, challenging the Department of Corrections' prohibition of same-sex kissing and hugging during prison visits. The Department of Corrections contended that its policy protected inmates from being labeled as homosexuals and from being targeted from abuse by other inmates. Judge Tashima wrote that the visitation policy defied common sense because the inmate openly had told other prisoners that he was gay and openly displayed affection with his partner during prison visits. In another case called Jesperson versus Harrah's Operating Company, a case that generated a bit of controversy, Judge Tashima wrote a majority opinion upholding the termination of a female bartender at a casino who refused to wear makeup in violation of the casino's grooming policy. The basis for that decision was that the plaintiff had failed to create an evidentiary record demonstrating that the grooming policy imposed greater burdens on female bartenders than male bartenders. In the face of a vigorous dissent from Judge Sid Thomas, Judge Tashima held that binding Ninth Circuit en banc precedent in Frank versus United Airlines mandated the result because it required the unequal burdens test to be applied. That case generated enough controversy to then move on to an en banc review, which again resulted in a divided court, with Judge Mary Schroeder upholding the position that Judge Tashima took, and Judge Kaczynski writing a spirited dissent, saying, interestingly enough, that one can take judicial notice of the fact that it takes more effort for a woman to put on makeup than for a man to shave his beard. I could go on, but I don't want to take away time from the other speakers. So the conclusion from this exercise turns out to be the same as that found by that Vanderbilt law student. It depends. Judge Tashima's cases uniformly show a painstaking devotion to the rule of law and the application of that law to the facts in the evidentiary record, sometimes resulting in outcomes that cannot be pigeonholed. Let me conclude my remarks by mentioning how Judge Tashima has been an inspiration and a role model to me personally in my own career. After I became a practicing lawyer, I encountered various indignities that lawyers of color sometimes face, whether it be racial jokes or sometimes worse. Even though I didn't personally know Judge Tashima at that time, I admired him from afar. And given all the challenges that he and Judge Takasugi had overcome, it put things in perspective for me, that whatever problems I faced seemed minor and petty in the comparison. And then there came a day when I was a fairly junior attorney that I had the opportunity to participate in my very first jury trial in federal court. And that was in front of Judge Tashima. I might as well have been trying a case on Mount Olympus in front of Zeus. I was terrified. But Judge Tashima was chill. And he put me at ease by his dignified, calm, and no-nonsense demeanor. He tolerated the fumblings of a young attorney and never raised his voice or showed any distress during the trial, even though the basis for federal subject matter jurisdiction was civil RICO, the bane of all federal judges' existence. We ultimately received a favorable jury verdict, but not on the RICO claim. Since then, Judge Tashima has become one of my models of good judicial temperament, which provides a perfect segue into some of our next speakers' comments. Thank you.
My name is Eric Harrington. I'm also a former law clerk of Judge Tashima's. I want to thank Candace for putting this together with Kaipo's assistant. Is Kaipo still here? There he is, hiding up there. And when I was asked, do I need a mic?
No, it's me and Scott.
Oh, and Scott, of course, and I was getting to that. And when I was asked to talk, I immediately, of course, said yes, because I'm more than happy to come to praise Judge Tashima. There is not any day in my life where I don't have to thank Judge Tashima for the riches that I had. He swore me into the bar. He gave me the first job that opened up every other job I've ever had. He married my wife and me. She's very good. He did a good job with that. We considered inviting him to the labor and delivery room for our 2 kids, but thought that would be a bit much. So we didn't do that, but you probably didn't want to travel to Washington, D.C. anyway. So I am eternally grateful for what you've meant to me personally. But even beyond that, you know, you've become such a model as I've kind of transitioned in my career from being a really baby lawyer to junior to sort of in between. And now I start to mentor young lawyers. I often ask, what would Judge Tashima do? And I do my best to be as dispassionate and even-tempered, and is not as much my personality as it is the judge's. One of the things that I do in my current position is review and give advice on federal judicial nominations. I work for a large teachers union. I will tell you, the Trump administration doesn't really ask for our advice on their judicial nominations, but the Obama administration did. And Senate Judiciary Democrats still do ask our advice on potential nominations. And so you review records of various judges, usually when they're being, we care mostly about circuit nominees and Supreme Court nominees. And one of the things that is always a buzzword during these confirmation discussions and reviews is judicial temperament. And it becomes an issue that's discussed quite a bit during the confirmation process, and then it sort of gets dropped to the wayside. And we never really talk about a judge's temperament after that, after the initial confirmation. And in my experience, the conversation about judicial temperament tends to boil down to, is the person polite? Are they not rude in oral argument? Senator Rowe now asks if they've ever been involved in sexual harassment or sexual assault. So what kind of person are they personally? And it kind of gets boiled down to just, are they a decent person? And that's important if you're a lawyer appearing before judges. You know, being berated is never a fun process. But I think there's something more to that, and it speaks to Judge Tashima's approach to cases and to the law that, to me, is something that has lived with me both in my experience of what I witnessed and what I bore witness to, and then what I'm seeing in current nominees. Okay, so what do we kind of call judicial temperament? The ABA defines it in these kind of squishy terms. You have compassion, decisiveness, open-mindedness, sensitivity, courtesy, patience. Sounds like a good spouse, right? Freedom from bias and commitment to equal justice. Others will talk about whether you're even-handed, unbiased, impartial. I want to focus on 3 kind of aspects. And here the former history teacher in me is going to put them on the board for you. One aspect is that I want to focus on today is courage. The second aspect is commitment to process and not resolve. You think we all compared notes or something, but we honestly didn't. And then the other one I want to talk about is equal justice, and some have sort of described this as empathy. I like to think it was like almost more, empathy sounds like one of those squishy words, and I know President Obama got a lot of heat for this when he was appointing or nominating Justice Sotomayor. But I think it's really about perspective and the ability to see the world through other people's eyes. And I'm going to talk about 3 cases that I was fortunate enough to work with the judge, and not just me. These were kind of big cases that extended over a few terms. And so if those of you sort of playing at home, I'll give you the citations if you want to look it up with them. So 590 F3rd. Is this too small to read in the back? The problem with doing this is if I say something about the case that's incorrect, you all are going to know it right away. Okay, so the first case is Farrakhan versus Gregor, the former governor of Washington. Did I say the name right too? I don't think we ever had decided how to say this.
It's Gregoire.
Gregoire, thank you. Farrakhan Gregor was a case challenging Washington State. Washington State had a felon disenfranchisement law. And this was a case that challenged whether that felon disenfranchisement law violated Section 2 of the Voting Rights Act. Section 2 of the Voting Rights Act makes it unlawful to have any voting requirement that results in the denial of vote on the basis of race or color. And the plaintiffs in that case were convicted felons. And what their allegation was is that Washington State's criminal justice system was so infected by racial bias that the voting requirement or disqualification for being a felon meant that they were denied the right to vote as a result of their race. And it was a complicated case, and it had been it went up and down. And there was an initial panel in the Ninth Circuit that Judge Tashima was not on that held that the Voting Rights Act can be applied to felon disenfranchisement laws. And it went back to the trial court, and the plaintiffs put on in evidence, demonstrated, sort of did like what we would consider in employment discrimination law, indirect evidence of racial discrimination. They provided experts that showed that Washington State's criminal justice system, that there were all these decision points where people of color and minorities were treated worse than white potential criminal defendants. And you couldn't explain all of these decision points, from like higher arrest rates, higher incarceration, higher trial rates, longer sentences. You couldn't explain away those in race-neutral terms. And the state didn't actually contest those factual allegations and findings with their own facts. And the district court concluded that yes, there was racial bias in Washington State's criminal justice system that infected affected who was going to be a felon, and therefore was connected to felon disenfranchisement, but nonetheless granted summary judgment in favor of the state. And the case comes up on appeal. And in the meantime, before the first Farrakhan panel and then this new one, and the previous panel, speaking of judicial courage, they didn't take the case the second time. They put it back in the pool. And they drew Judge Tashima along with 2 other judges. And in the meantime, between the Ninth Circuit's initial decision saying that the Voting Rights Act applies to felon disenfranchisement, other circuits had held it does not. In fact, there are several. So this case comes up, and we have the basic contours of the case are, we got all these other circuits saying that felon disenfranchisement doesn't apply at all, the Voting Rights Act doesn't apply at all to felon disenfranchisement, mostly because the 14th Amendment specifically mentions that you can disenfranchise people on the basis of former incarceration. And you've got these uncontroverted facts that there's racial discrimination in Washington State's system that you can't explain away. And this case comes up, and Judge Tashima writes an opinion deciding to grant summary judgment in favor of the plaintiffs over a dissent. And the very first thing is, I want to talk about the courage of this decision. It was the only circuit that had at all decided that the Voting Rights Act applies to the situation, and then to have the courage to say, well, if the facts are uncontroverted, and of course, what did Judge Tashima do? He relied deeply on the rules of civil procedure. So Rule 56 of the Rules of Civil Procedure says, if you don't contest facts, you're stuck with them. If you're a defendant, you can debate inferences, but if you don't actually contest facts, you're stuck with them. And that was the thing that Judge Tashima, being the civil procedure guy he is, right? He just glommed onto that and said, well, they've conceded that there's racial discrimination in the criminal justice and it affects the voting qualifications. This is kind of over, right? And we weren't over, and he also, the courage of this, Judge Tashima understood well that this decision probably wouldn't last forever. And the dissent, who I won't name because I won't do that, but said the reason why the panel opinion that Judge Tashima wrote was wrong wasn't because of the actual law or the process of the facts, but it was wrong in part because Farrakhan 1 itself was, quote, places us in a crowd of one among the circuits, so the Ninth Circuit's alone, and then we should be particularly mindful of reversing the district court and invalidating felon disenfranchisement based on sort of the softness of the earlier precedent opinion that this new panel was bound to. So it was really for non-kind of process reasons. And then the third component here is the equal justice stuff. That Judge Tashima put himself in the spot of saw the world equally from the perspective of the convicted felons and applied the same normal kind of litigation rules in the state of Washington that they certainly would have done when it came to the plaintiffs. So if the plaintiffs had failed to contest facts, I'm pretty sure that it would have been not courageous to hold them to that. And the sort of the line here of these 3 points and his temperament holds true because this decision, which he sort of expected, was reversed by an en banc court of the Ninth Circuit. And the Ninth Circuit Court did not the en banc court did not actually challenge any of the bases that Judge Tashima's very well-reasoned opinion laid out, but instead really just undermined Farrakhan 1, saying, well, it's unlikely that the Voting Rights Act should apply to felon disenfranchisement, so we're going to create a very, very high burden for plaintiffs to show. That is that there's intentional discrimination in the criminal justice system. They can't meet that. The case is over. It's been now 10 years since I looked at this, and it really holds up, and I encourage you to look at it, of just this commitment to process and having courage and seeing the other opinions sort of fail in that account. The second decision that I want to talk about is Stormings versus Selecki. This was a case involving Washington State's, we're back in Washington already, yes, the Washington State's rule. Their pharmacy board created a rule that said that pharmacies could not refuse to dispense Plan B contraception to any woman, I think it's a woman, or anyone who comes and seeks a Plan B contraception. And they can't refuse to dispense the Plan B based on religious or moral objections. There was a free exercise clause challenge to this. There was a pharmacy, a company, and a couple pharmacists who said it violated their religious views to dispense Plan B contraceptives, and they moved for a preliminary injunction. And the preliminary injunction came up to the Ninth Circuit. And again, Judge Tashima, by himself, had the courage to write a dissent, which was ultimately the view that was adopted by the entire court. And I remember this, when Judge Tashima was nominated to the Ninth Circuit, as is often the case in nomination battles, abortion law and abortion politics becomes a big part of it. And I remember saying to him at the time that this was the case that he was nominated for, because I don't think he had had an abortion case before, and he, in his wry sense of humor, sort of cocked his half smile and said, no, this is the reason why I have life tenure. And this, of course, is the kind of case that will get you on Bill O'Reilly or whatever. But he didn't blink, and he sided with, and it's a very even-handed opinion, too, showing real ability to empathize with both the women seeking Plan B contraception and the pharmacists who had moral and religious objections to it. But nonetheless, he had the courage and the commitment to the process. And this is less of a process case. And then the third case that I want to talk about is Harris versus Castro, which is this case. This case involved a person convicted of a violent felony, who a previous panel that Judge Tashima also was not on held that he was convicted in violation of constitutional rights, and they had remanded his habeas petition for resentencing. And so they issued what we call a conditional writ, sends it back saying you can resentence him within a certain time period. And the state's attorney never got around to resentencing him, or taking any action to resentence him. And the case, and the prisoner says, hey, the window closed, the conditional writ has expired, I get the full writ, I get to be released from prison. And the case came up on appeal. And the very first question in the case is whether conditional writs at all can be reopened. And Judge Tashima was pragmatic about concluding that they were. But he applied then the rules of civil procedure, and he reached for Rule 60. And I think this is one of the first cases that filled in the federal rules of civil procedure as like a backstop to the rules of habeas. And he held that it was Rule 60 allows for reopening of judgments, post-judgments, and that there was no good cause to reopen the conditional writ, and he had the courage to order that the writ be issued. That case has become very influential in how habeas petitions are handled. So for my own experience of bearing witness, and I think what's coming clear from the other panelists, is that these kind of threads, and particularly a commitment to process over results, explains so much of his jurisprudence. And it is not as easy to sort of put him on an ideological line, but if we review his jurisprudence through this prism of commitment to process over results, it really starts to make sense and be very coherent. So with that, thank you, Candace, and thanks for inviting me, and thanks for the stop sign.
speak. Can everyone hear me okay? I'm going to speak without a microphone. A lot of our panelists have talked a lot about cases, which I understand you went onto a computer database called Westlaw and read those cases. I try to avoid that myself. So I will mention a couple of cases, but I'm not going to take a deep dive by anyone's definition. I thought, Candace asked me to talk about advancing justice. And, from my it's an interesting perspective. We've been talking about Judge Tashima's, contribution to the doctrine and to the rule of law, and I think everyone agrees on these sort of salient sort of character traits of Judge Tashima. He's independent, he has integrity, he's funny. I think everyone has mentioned his sense of humor. And he's this like warm, wonderful person, and he's also a legal scholar. But that's, and I think he has advanced the doctrine. I think he's advanced justice a lot by doing that. But I think really more than anything else, he's advanced justice because of his impact on the most vulnerable people. And so that's a little bit about what I want to talk about. I want to thank Candace for inviting me, and thank you to the panelists. I'm particularly honored to be on the panel with Judge G, who's fighting through not feeling well. If you wanted to do a symposium on Judge G advancing justice, assuming I'm welcome back after what I say today, I want to be on that panel. Because my experience with Judge Tashima was as a clerk, but I've practiced in front of Judge G, and a lot of the things that I have to say about him, I think would apply equally to her. So I clerked for Judge Tashima in 2003, 2004. I came to Judge Tashima after a brief stint at MoFo, same firm where Judge Tashima worked. And previous to that, I was right here at UCLA. I went to the public interest program, which if you haven't heard of that program or don't know much about it, I just really encourage you to learn. It's a radical program. It is essentially designed for people who want to make an impact in the world and who know that as they go into law school. And that was my position. I wanted to go to law school to save the world. I think a lot of people were there, but I was pretty serious about it, and I was doing, activist type work before I even came here. And so coming to law school really was a means to an end. I wasn't, to be honest, all that interested in legal doctrine. I wanted a license to practice law so I could mix it up and right the wrongs of the world. And coming to law school was a pretty eye-opening experience for me. It was, you go to law school, and especially a school of this caliber, and you're taught about the sort of integrity of the law and the history of the law and the value of precedent and how it has its own sort of moral authority just by the fact that it exists and it's, the product of a democratic process. But when you actually study the cases and learn the facts of those cases, you're just confronted every day with how the law just creates injustice all over the place. I learned about it in almost every context, but I remember in particular learning about it, I think in the classroom right over here, Professor Devin Carbato taught me criminal procedure, and you're learning about the Bill of Rights in criminal procedure, and essentially what he did is he taught us this is what the Bill of Rights says, this is how judges have interpreted it, and you're just shocked at the results that they come up with. And you're left feeling like, I gotta go fix that Bill of Rights. I'm like, they're getting it wrong, and we have to make it right. So I always knew I wanted to do some public interest type work, and my perspective, and I think sort of what guides my comments today, were my work as a federal public defender. So I was at the office, the LA Federal Public Defender's Office for 12 years, worked in the death penalty unit, but most of the time I was just, trying cases. And like judges, I get whatever comes in, so you range everything from your drug cases to your prison escapes to your, what we had, trespassing on the habitat of the snowy plover, whatever, postal theft. And anyway, my experience was, and my perspective was, I'm going to advance justice by using my legal education to make people feel empowered, to get them their freedom back, but also just to make them feel seen and valued. And part of my agenda was not just learning to be a skilled lawyer so I could help them, but also making them feel like, as a consumer of justice, not on the end that any of us would want to be, they felt they got their money's worth. I wanted to be as good as any of the best, high-paid lawyers. And I wanted them to feel that, whether we won or lost. And so that's my background. When I went to clerk for Judge Tashima, I figured, well, he has this reputation as like this legend in the civil rights community. He's known as, his personal experience is very well known. I was delighted beyond you know, all expectations when he offered me a clerkship. It was a wonderful year, and I won't go into that because a lot of us know what that was like. Michael Roth is nodding his head. He was a co-clerk of mine, you know. But what I think I admit that I went into it thinking, well, this is going to be a progressive. This is like a liberal judge, right? So he's going to share my values, and he's going to be, you know, he's going to have the same sensibility that I do about how we're going to like change the world. I didn't share that expectation with him or that view. What happens is you go, you know, you start your gig and you're just in awe for the first month or two, and by the time you recover from that, you're almost done. But what I found was this like rigorous legal thinker who had this tremendous respect for precedent, tremendous respect for the integrity of the law. All the stuff that law school taught me not to respect, he respected it. And it was a little confusing. And so, you know, when you look at his decisions, and I sort of echo some of Judge G's comments, you know, I think people tend to expect that your jurisprudence is going to be shaped by your life experience. They want to put you in a box, and I think that's kind of what I did with Judge Tashima, and that just wasn't true. But what I found was that the law had a lot more integrity and a lot more power to make change than I really gave it credit for based on my law school experience. And I don't think that this is a sensibility that's shared by all judges. But Judge Tashima really was someone who, you know, I tried to sort of think about how to describe what I saw as his judicial philosophy, and what I wrote down was radical fairness and a fundamentalist impartiality. It doesn't make sense, but what the product winds up being is decisions of doing the right thing all the time, regardless of what somebody might think of it. And I think Eric mentioned courage. And I thought about that too, and I thought about if I were in Judge Tashima's position, it would take courage to make some of those decisions. But my honest assessment of his approach is I'll bet he wouldn't see it that way at all. My experience working with Judge Tashima is that when he saw what the right thing to do is, he never blinked. He never gave it a second thought. And so that changed my perspective a lot. And as I went out into the world and I did all the things, you know, I basically went and represented like poor, mentally ill, marginalized people. I presented very difficult arguments to judges, and I asked for them to do radical things to change people's lives. But my sort of expectation and my belief that judges could actually use the rule of law to actually reach those decisions was sort of rejuvenated. And so there's two cases. I'm going to talk about two cases. And if you know more about these cases than I do, I just kindly ask you not to mention it. Both of them are criminal defendants, and both are examples, I think, that really kind of show Judge Tashima in his element of doing the right thing regardless of what anybody thinks. The first is United States versus Buckland. Do you have any sort of sentencing nerds in here? Apprendi nerds? In 2000, the Supreme Court decided Apprendi versus New Jersey, which essentially said that any fact that raises the statutory maximum exposure of an prior conviction of a criminal defendant must be presented to and proven beyond a reasonable doubt to a jury. And in that decision, I think it was one of the dissenting justices said, well, you know, guys, if we hold this, then we're basically saying that the federal sentencing guidelines are unconstitutional. And it's right there. And the majority brushed that off. Nah, that's not a thing. Along comes Calvin Wayne Buckland. He was, I guess as we used to describe it, mistakes were made and they involved drugs and weapons. Nobody's perfect, but yeah, so he wound up with 824 months as a result of those mistakes. He comes to the Ninth Circuit with an argument that, well, you remember what they said in Apprendi. That means that, you know, the Controlled Substances Act is now unconstitutional because, as we can all see, the text of the statute treats drug type and quantity as a sentencing factor that the judge gets to decide, and that's how it had been interpreted since the very beginning of time. Now, and the reason I say, and again, I say courage because I think an ordinary person might have thought it would take courage to just sort of declare the Controlled Substances Act unconstitutional. I doubt that's how Judge Tashima saw it, I don't know. There were ways to avoid this problem. There were ways to decide this case in a more narrow way. In fact, the Seventh Circuit had confronted this very same problem and said, well, yeah, it's probably bad the statute probably kind of could be read to say that, but we're gonna interpret it to avoid that constitutional problem. So there's the canon of interpretation that you should interpret a statute in a way that renders it constitutional if you can. And Judge Tashima took a look at it and said, no, I don't think we're gonna do that. And so in this wonderful published decision that sent a ripple through the criminal defense community during that time, he declared the Controlled Substances Act unconstitutional. Like so many of Judge Tashima's wonderful contributions to the doctrine, it did not survive. He was ganged up on by a majority of the non-bonk panel. But that stuck out to me as something that was that's advancing justice. And I think, so what I thought I would do is, what I think is missing sometimes from our discussion is how does this affect the people on the ground? And that's something that I saw a lot. And I've mentioned these decisions from the Supreme Court that basically recognize and honor the Bill of Rights, they do trickle down, they do mean something. You go into a prison to see your clients, and they've heard about it and they want to talk about it, and it gives them hope and gives them new perspective. In this particular case, Cal Buckland was resentenced, I think, to like 300-something months. But I looked it up just to see kind of what happened to this guy. He was released so he would have been in prison still. He was released October 30, 2015, and he died a year later. And so when you talk about advancing justice, like, this decision, and again, I'm sure Judge Tashima didn't have this in mind at all, but this person got to live a year free because of the decision, because of what Judge Tashima did. The other case, and I'll just mention it briefly, but I think it stands for the same principle, is United States versus Vargas Amaya. Now this one I'm fairly confident no one would have heard of or cared about. Anyone ever heard of this case, United States versus Vargas Amaya, except for Michael? This was, so if Apprendi and Buckland were sort of giving life to the Sixth Amendment right to a jury trial, United States versus Vargas Amaya was about the Fourth Amendment. And the case was about this. When you're sentenced to a term of supervised release, which is just a term of supervision after you finish a prison term, you can be violated. If you commit a violation of your supervised release terms at any time during your supervised release term, you can be cited back into court, and you can be sentenced back to prison. Now there's a statute that requires that if a probation officer thinks that there's a violation of supervision, they must issue a warrant within the term of supervision. Now, if a hearing needs to be held after the term of supervision is over, that's okay, but only if a warrant is issued within the term of supervision. So some creative litigant, a federal public defender, looked closely at these warrant forms that were being submitted by the probation officers, and what they found was these forms did not have a declaration under oath by the probation officer. They just said, I declare that this is true, but didn't say under oath. And so some very clever litigant said, well, that's not a warrant. That's just a statement that I violated. So you don't have jurisdiction to put me back in prison. District court, of course, found that frivolous. It comes up, Judge Tashima takes a look at it and he says, well, it says there has to be a warrant. A warrant is referred to in the Fourth Amendment. We all know what a warrant means is a statement that's supported by an oath. There's no oath here. And basically dismisses the case, or basically fines for the defendant. And at this time was when I was back, and so this actually happened while we were clerking. So I went to the Federal Public Defender's Office, and Judge Tashima was a hero. I don't know if he intended this, I doubt it. But what this wound up happening is hundreds of people who were being violated, and I should mention, I think it's worth pointing out, they're being violated, maybe they committed a new crime, more likely they, relapsed, or they left the jurisdiction without permission. And they were at risk of being put in prison for years more, potentially, based on what might be a minor violation. All those people got a free pass. And, on one level, if you're a guy who's gonna get in trouble and you don't, you're just gonna be happy about it. But I mention this because when you explain, and I had many clients that I explained this to, when you explain why this happened, and you say, listen, the reason this happened is because the judge looked at this warrant and said the Fourth Amendment applies to you. And the Constitution means the probation officer can't do this, and they had to take a step and they didn't do it, and you're going free because of that, it sends a ripple, and it changes that person's perspective, just like sort of my perspective was changed, and they think, wow, these are people who've been failed by their parents, their teachers, public officials. And all of a sudden, a federal judge who's appointed for life decides that they want to issue a decision that impacts them positively, it has the power to do so much. And so I think sort of my general point is this. Advancing justice, if you're a judge, doesn't mean that you know, there are judges that are sort of seen as progressive or liberal, and they look like they're result-oriented. But when you can advance justice, and I think Judge Tashima has, just by following the rule of law and applying it faithfully and giving people, especially in the criminal justice system, a sense that they're going to be treated fairly and the rules apply to everybody. And so I figured that's, you know, so when I think about the contribution to justice from the perspective of my clients, that's the way it took shape. And so I'll leave you with one quote, which sort of summed it up. This was from a case called the United States versus Hyatt, and this was a stinging dissent from Judge Tashima. Got a lot of media attention as a terrorism case. And I'm not going to talk about the case, I'll just say this. The quote was, the primary constitutional duty of the judicial branch is to do justice in criminal prosecutions. Just saying that out loud, and Candace pointed that quote out to me, just saying that out loud and meaning it means so much. And I think it really kind of captures your contribution to justice. Thanks.
Thank you to all three of you. That was so fabulous. We have about 5 minutes for any questions. If anyone has any questions of anyone?
If there's time, I'd like to read a brief statement that Judge Consuelo Marshall wanted me to convey.
Oh, thank you.
On the occasion of this symposium. She said, Judge Toshima and I were appointed by President Carter as United States District Court judges to the Central District of California. He was one of the first Carter appointees, and I was one of the last. Judge Tashima was very helpful to me during the appointment process. He was active in the American Bar Association, and I was not. He knew some of those who were involved in the process in evaluating nominees for the federal bench. He shared my background and qualifications with people that he knew and introduced me to some who ultimately interviewed me during this process. This was quite helpful for one who knew very little about the process and what to expect. Once I was appointed to the court, he became one of my mentors. He always took time to answer questions about new and novel issues and reminded me that the job was not only working on cases, but I also needed to be involved in court governance. We both served on the Ninth Circuit Pacific Islands Committee, training and assisting the courts in Guam, the Commonwealth of the North Mariana Islands, Palau, American Samoa, and the Federated States of Micronesia. When he was no longer a member of the committee, he continued to volunteer to assist those courts. He was appointed by the Department of Interior to sit with the appellate courts of American Samoa and the Marshall Islands, along with local judges in those jurisdictions. It is my honor to share a few of my memories about someone who is so deserving of this recognition.
That just reminded me of one thing. We had a panelist who was going to speak to Judge Tashima's work. I don't know if you all know this, but Judge Tashima used to travel around the world to help other countries set up their alternative dispute resolution procedures. And Steve Mayo worked with the State Department, and he said Judge Tashima was instrumental in going with him, just traveling to these places, listening to their judges and helping them to choose lawyers and train all their lawyers. And he said that he could not have done it without him. And so I was sad that we didn't have Steve Mayo here to speak about that, but just what you were saying about his work on the Pacific Islands reminded me of that. So unless there's another question, then I think we'll finish up here with this panel. Thank you.
Our last panel. So we, of course, like to thank everybody who's presented so far. It's been great. We have one more panel, which is called Advancing the Profession, and this is focusing on Judge Tashima's contributions as a mentor and a role model to younger attorneys. So we're going to go in alphabetical order. We'll start with Halim Chen, who's a partner at Munger, Tilton Wilson. Then we'll have the Honorable Halim Dhanidina, who is an Associate Justice on the Court of Appeal, 2nd District. Then Judge Elaine Liu, who's a judge on the Los Angeles Superior Court. And finally, Michael Roth, who's a partner at Boyce Schiller Flexner LLP. So, without further ado.
Hello, everyone. I'm Halim Shen. As Kaipo said, I'm a partner at Munger, Tolles & Olson. I've been there for pretty much my whole career. I went to law school here. I took immigration law in this classroom. And I'd like to start by talking about Judge Tashima's contribution to the advancement of women in the profession. When I started law school here in 2000, our law school class was 55% women. 55%. It was, you could see it. In fact, I still remember my first day orientation walking in, and I was standing next to a couple guys who were really bro-y, and they see the crowd, and they were like, whoa. So it was 55% women. And for over the past 2 decades, law school classes have been around 50%, sometimes over 50%. But the numbers in the law firm leadership ranks are different. Those numbers remain stagnant. They've risen a little bit in the past few years. They're right now, according to the NALP numbers, women in law firm partnership, about 24%. The numbers of minority women are even lower, 3%. And research has shown the reasons why. As you might guess, a lot of it has to do with motherhood and what happens when women leave for a little while to have a baby. The inflexibility of law firms, people's perceptions of motherhood, those affect women's ability to come back and to have the opportunities they need to advance. Women find themselves profiled in a way. Mothers are viewed as less proficient. People question whether mothers are as committed to their jobs as they were before. Benevolent bias can play out. So people will say, well, she's a mom. We're not going to send her to that out-of-town deposition. Or she's not going to want to travel. She's got little kids. We're not going to put her on that 2-week trial. And women leave the profession in much larger numbers. They leave law firms and they leave the profession entirely. Very recently, in this past month's issue of The American Lawyer, our firm was profiled in an article by Vivian Chen that got a bunch of news for being a woke, her word, law firm. What made us so woke? We made a bunch of people partners. 2 of them, amazingly, the same year, they took parental leave. That made us super woke, apparently. Well, Judge Tashima was woke before that was even a thing. So, in 2003, I was graduating from law school. I started law school with a 2.5-year-old. I had my second daughter, Claire, at the end of my 2L year. And John Luttrell probably remembers me. I think you were sitting at like the back of some evidence class, and I'd always walk in like hugely pregnant. So I had 2 little kids. And I wanted to clerk for Judge Tashima. I was friends with one of his clerks, and he gave me a call as a sort of heads up. Sorry I'm revealing this, to say like, hey, we're gonna make you an offer. Just giving you a heads up so it doesn't surprise you. And I said, oh, that's awesome, but I was kind of thinking it might be nice to take a year off to just be home with my girls. You know, finishing law school with a 2.5-year-old and a newborn baby during my 3L year, that's been really, really hard. And it would be really nice to just have a year off. And he was like, are you nuts? This is a Ninth Circuit judge who is offering you a clerkship. You can't say anything but yes. And I thought about it, and I thought, well, what's the worst that could happen? So I get the call from Judge Tashima. He makes me the offer. I say, oh my God, I'm so excited. And I say, but I have one question. I really want to take a year off to stay home with my babies, just for 1 year. Can I put off my start date by a year? And he sort of thought about it for a moment. I think he was maybe taken aback, I don't know. And he says, okay. I mean, it was the easiest thing, and I was like agonized about it. Should I do this? Should I ask? Oh my God, I gotta work up the courage. And I went to work for Judge Tashima. At the time, my daughters were 6 and 2. All three of my co-clerks are here today. Vicki Bush, she had a daughter, Annika, who is a year old, and I believe you interviewed by video conference while you were pregnant.
I was 8 months pregnant, I couldn't fly.
Yeah.
And so he interviewed me by video. Thank you, Judge.
And of course, Candace, with her 2 boys, and also John. Who had to put up with us talking about our kids the entire time. And did so with good cheer. But the entire time I clerked for Judge Tashima, I never experienced any of those things that you read about in the literature today. I never experienced him saying, well, I don't know if we could give her this because that would mean she'd have to travel. I don't know if she's committed to her job. I never experienced any of that. And that was a formative experience in my life. And not only did it affect me, but I'm certain it had an effect on the other clerks. The other clerks who were doing the interviewing and who were doing the hiring, who could hear Judge Tashima say, well, yeah, let's just give her another year, so we'll stay home with her kids and then she'll come. What's the big deal? And that is what is fostering change in the legal profession. Our firm comes to this law school about every year to do a panel on what it's like to be a parent in big law. And I will say that over the 10 years that I've done that, the first time that I did it, I think it was in this room, the audience was 100% women. Today, when we do it, it is 50% men. And it is men who do not yet have kids. Men who do not yet have kids who want to be equal parents, who want to know, can I be the kind of parent I want to be and also work at a big firm? It was funny because we on the panel were talking about, can you be the kind of lawyer you want to be and be a parent at the same time? And it was the men in the audience who don't even have kids yet, who aren't even in relationships. I mean, this just blew my mind, right? They were saying, no, I want to flip that question. I want to know if I can be the kind of parent I want to be and work at a big firm. The second thing I want to talk about, and we heard about this a little bit from Judge G, is the importance of representation and why representation matters. You heard about the statistics of no Asian American judges at the district court level for years and years and years. And there's perhaps no other place in the country where that had a bigger impact on the jurors, perhaps in the litigants in the courtroom, than in Hawaii. Judge Tashima, on a number of occasions, has sat by designation on the district court in Hawaii. I think sometimes when all the other judges have to recuse themselves for some reason. And we were lucky enough, during my clerkship, to get to go to Hawaii to watch Judge Tashima preside over a trial. It was such a Hawaii case. It was a criminal trial, and it involved a number of people who had worked at a tax preparation shop, and they were pushing this idea that, oh, we can lower your taxes by claiming that Hawaii is a sovereign nation, right? And so all of this income that you've earned in Hawaii, that's foreign income. So they were prosecuted criminally. John is like, what's the big deal? I'm kidding. And so we're in this big, magnificent courthouse. We're sitting up there, and what I didn't know, but it seems like it should be obvious, it may surprise you, the federal jury pool in Hawaii, they fly people in from all the islands. So people flew in from Hawaii, people flew in from Maui. You have this huge jury pool in there, and they all look like Judge Tashima. They all look like me. We are in America, in a federal courthouse, and we look like the majority. And it was an amazing experience to see the jurors' faces as they came into the courtroom, this imposing courtroom, this embodiment of the United States government, and to look up and to see the judge be someone who looked like them. And it had to have contributed to their view of fairness, their trust in our institutions. I am on the Board of Trustees of the State Bar of California, I'm missing a board meeting right now as we speak. And yesterday we spent a whole day talking about strategic planning around diversity and inclusion. And it was my job to put on a presentation about some of the data that's out there about demographics amongst attorneys who practice in various sectors in California. And one of the studies that I talked about was a study put out by the Stanford Criminal Justice Center. In 2015, they looked at all the California prosecutors, and what they found was this. Even though, well, first of all, 70% of prosecutors in California are white. Even though 40% of the population is Latino, only 9% of prosecutors are Latino. And the study talked about why that makes a difference. And some of those may be obvious too. It's prosecutors who decide whether to charge. They decide what to charge. They decide what sentence to ask for, what concessions to offer in exchange for guilty pleas. They really dictate the outcome in the vast majority of criminal cases, right? The ones that don't go to trial. That really dictates the outcome. And in a day and age when our criminal justice system has many problems with race, these demographics make a difference. But they make a difference for another reason. They make a difference with respect to perceptions of fairness and trust in our institutions. And then I will say one last thing about representation. And there are a lot of thoughts that have gone through my mind. A lot of them are unformed, so bear with me if I don't get it out quite cleanly. I haven't practiced this. But we're living through some dark times. And, you know, all over my Twitter feed, I read a lot of Twitter. I'm on Twitter all the time. People of color, children of immigrants, saying things like, I'm having to prove on a daily basis that I'm worthy of existing here in this country. I've had the privilege of participating in the swearings-in of the latest 2 classes of new attorneys in California, you know, based on my role at the state bar. And I look out in the audience and I always have asked them, with a show of hands, how many of you are the first person in your family to go to law school? And it's amazing. So many hands go up. How many of you are the children of immigrants or immigrants yourself? So many hands go up. And I wonder, who are they going to look to as role models? I wonder for myself, who do I look to as a role model? As Judge G mentioned, you know, being an Asian American woman in a role of leadership in the law, in partnership in the law, it's hard. It is really hard. I represent some big clients, and I walk into those meetings, they still wonder whether I'm bringing the coffee. I walk into court and I still get asked, oh, the interpreter goes over there. Are you here to be the court reporter? I walk into rooms where I am the only person who is not white. I walk into rooms where I am the only woman. And I am constantly having to prove that I belong there. Other people walk in and they start with a baseline level of assumption that they belong there. I'm down here and I gotta prove that I know my stuff. And I think about the stuff that Judge Tashima went through. Not being able to get hired when he came out of law school. Being only one of 4 Asians in his Harvard Law School class. And to say nothing of his experience with Japanese internment. About 10 years ago, I attended a wedding that was presided over by Judge Barrington Parker on the Second Circuit, who also was at Morrison & Foerster. And in chatting with him, you know, I said, oh, I clerked for Judge Tashima, and he said, Wally, he's who I want to be when I grow up. And in talking to him more, you know, for him, for Judge Parker, an African-American judge, growing up with the scars and the legacy of chattel slavery, wondering what it means to be an attorney of color, and then a judge of color. What does it mean? Who are your role models? How do you bring with you who you are to your job? And Judge Tashima, I think, as you've heard all through today, he's done it by fidelity to the rule of law, holding the government to its burden of proof, and being an unstintingly generous colleague and mentor. Thank you.
Good afternoon, everyone. I was invited to come and speak on a topic that is very close to me, and I feel it's one that connects me with Judge Tashima, who actually I've just met today. I don't have a history with him, professional history, having worked for him or in his court or anything like that. But I feel like I've known him from afar because of some common experiences that we have and a way that makes him a mentor to me. I think I'm also here because I'm also a graduate of UCLA Law School. I think it was contracts and prim law that I had in this classroom. I remember it being bigger. It's just a weird experience. So the topic that I want to address, and I'm going to maybe steal a little bit of the diversity conversation a little bit later, but it has to do with the concept of being a trailblazer. This is something that, a label that we give to people within the profession or within any particular field, oftentimes because of an accomplishment, where they've arrived, what they've had to go through to get to where they are. And usually they're the first or among the first to make some of those achievements. And so obviously we know this is a label that applies very appropriately to Judge Tashima. It's the reason why I think a lot of us are here, because of the trail that he has blazed in his profession. But I want to dissect the term a little bit too, because a little bit about my own personal background. I kind of charted my own course, both as an individual and as a member of the Muslim community in the United States. Kind of like what you've just heard, I'm the child of immigrants, first to go to law school. So that was a new experience in many ways in my family. I had a career as one of the few non-white prosecutors in the state, working for the DA's office before working on the trial court, the Superior Court of Los Angeles. And then something happened. As my career was progressing as an attorney, it was suggested to me that I apply to be appointed to the court as a Superior Court judge. And at the time, that whole process seemed so daunting. I didn't really think much about it, other than to just start filling out the paperwork and the essays and sending it in. And then at some point, the application just kind of died and then was revived when Governor Brown took office, and I received my appointment. And something interesting happened on that day, and there's a lot of judges in here who I'm sure will remember in detail what that day was like when they first found out that they received an appointment or were becoming a judge. The governor's office asked me first to confirm a lot of my biographical information, where I went to school and where I worked and that sort of thing. But then I remember his press secretary asked, "I have a question for you. Please feel free to say no." And at that moment I should have said, "There's a problem." But she said, "The governor is aware of the fact that your appointment will make you the first Muslim to be appointed as a judge in the state of California. And he's proud of that fact. He would like to put that in the press release." And I was a little bit surprised at first, because I thought, really, the first one? Because this was in 2012, and that didn't seem right in a state like California, as large and as diverse a state as it is. But of course, at the time, this was in the conversation where they told me I was going to be appointed, so I was like, yeah, sure, whatever, put whatever you want in there. And I didn't even think about it. And then shortly thereafter, the appointment received a lot of attention, as you might imagine. Positive attention, sure, some negative attention, but a lot of attention nonetheless. And I found that my role as a judge was beginning to take on so much more meaning than me trying to figure out how to do the job. It was a symbol, both, again, a symbol, a good symbol and a bad symbol, depending on who you were asking. And there were moments where I thought, is this really something that I want to burden myself with? Like, should I have just said, you know what, let's keep that out of the press release and thanks for the job and just soldier on. But then I began to sort of realize that that greater meaning had some opportunity and also perhaps some responsibility. And I'm sure Judge Tashima can relate to this. Being the first of anything in your job or within a community can kind of take away from what you feel your own personal achievements are. Because, you know, anytime anyone wants to talk to you, or they want you to speak at something, or they want to write something about you, that's always the angle. Kind of like, you know, ooh, you're the Muslim judge. In fact, just recently I was on a episode of Frontline where they interviewed me and filmed me, you know, in court and doing things. And it took on the feel of sort of like National Geographic, like we had found the Muslim judge in his habitat. and my parents, for example, they would read some of these things and they would be like, you know, why do they always have to talk about this? Why can't they just talk about you, you know, as a lawyer or as a judge and what you do professionally? Why does it always have to have this label? And I would kind of just joke about it and say, well, you know, it's what makes me interesting. Otherwise, it's, you know, who would want to talk to me? It's just, it would be boring. This sort of gives people, you know, an angle. But over the years, I've come to embrace it because I think I am beginning to understand the importance of what it really means, that it's really not so much about me as an individual. And that opinion has been informed in many ways by Judge Tashima's, the things he has said, the things he has written, and his actions within the community, and he's been a role model to me in that regard. Being a trailblazer is not so much, in the sense that Judge Tashima is, and in the sense that I hope to be, it's not so much about who you are, but it's about what you do. It's not a question of, now I've achieved this thing. It's more about, what am I going to do now that I am here? And how am I going to benefit other people in this capacity? And that, to me, I feel embodies the spirit with which Judge Tashima has lived as a role model to all of us here. Achieving things, to be sure, at times when other people didn't have them, but in that time since, constantly being that presence and that guidepost and that standard for us to try to live up to. And this has very real practical consequences, I think, within the legal community. You know, we talk about diversity and inclusion, and when you're trying to think about what you want for yourself or for your career, the first thing you naturally would do is look to see who's already there, who's already in that place, and how did they get there, and am I like them? Can I be like them? Can I do what they have done? And, you know, it's superficial to say, but if you feel like you can't relate to someone personally, either because of their experience or frankly even how they look, you're hesitant. You feel like, you know, that's not really for me. It's part of the reason why through my whole career in the DA's office, I never really thought about ending up on the bench, because it just didn't seem like something that was very realistic to me. But the more our profession becomes diverse and the more that the bench becomes diverse, I think there are more attorneys who then are asking that question, you know, why not me? You know, why do I feel like I'm starting all the way down here and everyone else feels completely comfortable starting up top? And I think that's important. That's important for all of us. It's a responsibility, not just for those who come first, but for those who follow, to look behind and see who's coming up next. That's a spirit, I think, with which Judge Tashima has held this position, you know, within the community as a trailblazer and as a mentor to other people. Another thing that I think, something that's personal to me, not just professional, that has really touched me about Judge Tashima and what he has done with his platform, has to do with some of the things that he's written about, and specifically as it relates to my community, the Muslim community within the United States. Judge Tashima is not shy about sharing his personal experiences with people or with his history with people. He gives interviews. He's written about his family's experience through the internment during World War II. And that's important because he could have done what I was tempted to do, which is to say, you know what, I'm a judge because I'm a good judge, and all that past history that has nothing to do with what I'm trying to accomplish as a professional. But he sees the importance of drawing a connection between his personal experience and the wisdom and perspective that it has given him, not so that it would just help his community, but really all communities that are in this constant struggle for acceptance and for equality and fairness within society. And that has become especially more real for me as a Muslim, obviously after 9/11 and the beginning of the War on Terror. And Judge Tashima wrote very eloquently about how we in the United States, we have this democracy and we think it's this great thing, but it's really only as strong as its participants. And ultimately, our civic institutions are there to maintain the democracy and to keep it healthy, and chief among them are the courts. The courts are the place where you go in order to achieve that fairness and equality when you're not able to get it through the rest of our institutions. And when the courts fail, then it all falls apart. And you can look at the internment precisely through that lens, right? When there was an opportunity for recourse to the courts let democracy down. We've all read about the Korematsu case and what that means. And in many ways, it's the height of irony that it was overruled in the Trump v. Hawaii case. But I asked myself, if there had been a lot of Judge Tashimas on the federal bench at the time that that case was percolating through the system, might the outcome have been different? Right? It's easy to dehumanize people or think a community is less than or foreign if you don't really know anyone in that community. So if the community of judges had to ask themselves, are Japanese Americans full, equal, participating, loyal citizens like we are? Or are they foreign? Well, it's so much easier to view them as foreign when there just aren't any represented in that population. Now fast forward all of these years, and Judge Tashima, I think in an article he wrote almost 15 years ago, 13 or 14 years ago, sort of forecast where we are now, and certainly where we were starting at the beginning of the last presidential campaign, where people were talking openly about how, Korematsu is still good law, and if we have to make Muslims carry IDs and identify themselves and be on a registry and maybe even incarcerated, rounded up for administrative purposes until we can figure out what's going on, there's no reason why the Constitution says we can't do that. And Judge Tashima, I think, very passionately, but also from an intellectual standpoint, was kind of screaming into the void, telling people, look, we've been through this. We've done this, and it was a mistake, and we all agree that it's a mistake now. Why on earth would we do it again? And sure enough, it all kind of came to pass. And now we're in the situation where I ask myself, if there were a lot of Muslims on the federal bench in the courts, would the Supreme Court have looked at that case differently? I don't know. There are no Muslims in the federal court, as judges at least. So when I think of what it means to be a trailblazer, to be first for my community, that's the way I want to think about it, the way Judge Tashima thinks about it, which is not so much an accomplishment or a badge that you wear, a badge of honor, but it's more a calling and a responsibility. And something now, because of circumstance, you are now put in a position to affect change in a positive way. And so, as personally and as a professional, I want to thank Judge Tashima for that guidance.
Hello everyone, my name is Elaine Liu. I was a law clerk to Judge Tashima in 1995-96, his inaugural year in Pasadena. And I know that several of you here had the privilege of clerking for Judge Tashima, so you are already well aware of what a wonderful mentor he is. But I just wanted to share this experience with some of you here who may not be as familiar with this important role that he's played in so many of our lives. Now, of course, we hear all about how the federal judicial clerkship application process has become so increasingly competitive, and even when I was applying some 20 plus years ago, I pretty much felt that I was going to say yes to whatever judge would give me an offer. So I wasn't as qualified as Halim, so I wasn't going to take any chances, and so I pretty much decided ahead of time that I was going to strike when the iron was hot, and if any judge gave me an offer, my answer was going to be yes. So the point of this is that the whole process is quite fortuitous, and who you end up clerking for is quite fortuitous. Well, it turns out that I landed a jackpot with my clerkship with Judge Tashima, and I immediately got a sense of this even before I started, because before I started, people would ask me, well, who are you going to be clerking for? I would tell them, and then I got the same universal response from all of them, this look of awe and wonder, like, how did you get this clerkship? So needless to say, I felt pretty daunted even before my first day on the job. Well, Judge Tashima made me immediately feel at ease. His chambers were always a warm and welcoming place to work, and he made it a perfect learning ground for fresh out of law school grads. A place where you could find stimulating intellectual discourse, and Judge Tashima really taught me how to think and write like a lawyer during my clerkship year. How to carefully look at the facts, how to stand firm on the questions that matter, and how to polish my legal writing. Judge Tashima has this unique ability to dissect through all the issues and hone in immediately on the ones that really matter. And I really feel that my legal education wasn't complete until my clerkship year with Judge Tashima. And it was so inspiring to see someone be so disciplined as to work all hours of the day and night and still find so much joy and enthusiasm for his work. Well, my clerkship may have ended 22 years ago, but I haven't stopped learning from Judge Tashima. I currently sit on the Los Angeles Superior Court as a judge, and every now and then I might encounter a particularly thorny legal issue or a difficult situation. As you can imagine, sometimes emotions run high between the litigants in my courtroom, and sometimes I feel myself getting flustered. So on many occasions, I take a recess, I run off the bench into my chambers, and I sort of hit my reboot button, and I ask myself, okay, well, I know that none of this would fluster or ruffle Judge Tashima, so how would he do this? What would he do in this situation? So he is my reboot button and my guiding compass all in one, and just having the image of his calm and patient demeanor somehow grounds me and gives me the confidence to go back out there in court and make things better. I'm also grateful because Judge Tashima, long after my clerkship ended, Judge Tashima has continued to make time to actively mentor me. I think of myself as a work in progress, and so he always goes out of his way to shape and help mold my career. He's great about keeping in touch with all his former law clerks, and whenever I see the judge, he'll always ask me if I've had any recent trials, what cases I've been working on. He really takes a genuine interest in following my career. I can't tell you how many countless times in the last 22 years Judge Tashima has helped to advance my career, either with his sound advice or his generous offers to serve as a reference. And it goes without saying, of course, that Judge Tashima's word carries a lot of weight and it goes very far. So this past week, I thought I'd reach out to some of his other former law clerks to see if they shared the same experience, and I received an overwhelming responses. And the funny thing was, this whole time I kind of thought I was special or something. But it turns out, no, Judge Tashima has poured his time, his attention, and concern for all of his former law clerks, following each of their careers and offering a helping hand. So whenever he travels to other parts of the country, Judge Tashima is so good about looking up his former law clerks and inviting them out to lunch. And if you think about it, one of the greatest legacies that a judge leaves behind, apart from contributions to jurisprudence, one of the greatest legacies would be all the law clerks that the judge has trained and mentored over all these years. Well, so far there are 107 of us lucky beneficiaries of Judge Tashima's wisdom and generous stewardship, and some of Judge Tashima's former law clerks have moved on to become partners at some of the top law firms. I think that Munger, Tolles & Olson is forming a Tashima Law Clerk Alumni Association. But really, all the top law firms across the country, in wide-ranging practice areas, everything from cybersecurity and national security to criminal defense. Other former Tashima law clerks have followed his example and become happy and fulfilled, long-term, dedicated public servants in our justice system, serving in public defenders' offices, county counsel's offices, U.S. attorney's offices, the Civil Rights Division of the Justice Department, legal services such as Betzedek. Other Tashima law clerks have capitalized on how we were all trained to think very deeply, and they now have advanced to become professors and deans at law schools all across this country. Michigan State University, Thomas Jefferson, Duke, Willamette, Vanderbilt, UCLA, Loyola, Berkeley, and Arizona State University, just to name a few. Some of these former law clerks in academia have recounted how they've brought their law students to meet the judge, and how Judge Tashima is so very kind and generous, sitting down with these law students to have lunch with them and to talk with them about their plans and their aspirations. Now, some of the really, really brave former Tashima law clerks have ventured outside the law entirely to head up nonprofits and to become leaders in higher education academic institutions like Stanford. And finally, of course, some of us have followed in Judge Tashima's footsteps onto the bench. And I count 2 of us on the LA Superior Court, 2 are now serving on the California Court of Appeal, and 1 on the federal bench as a U.S. magistrate judge. Now, we may have each chosen different career paths after our clerkships ended, but there are definitely some similarities among former Tashima law clerks. We all admire his ability to simplify things and cut right to the heart of the issues, and we all try to apply that in our daily lives. All of us credit the judge's superb guidance and his edits on our bench memos, our memorandum dispositions, our draft opinions, as what transformed us from law school students into lawyers. All of us, I think without exception, all of us are in awe of Judge Tashima's prodigious work ethic. We watched when Judge Tashima sat on the district court how he asked to sit, and he was invited to sit on so many different circuit panels with the Ninth Circuit. And since his elevation to the Ninth Circuit, he's always raising his hand to volunteer to preside over trials. We just don't see many judges like this who are volunteering and asking for more work. And despite being on double duty all these years, Judge Tashima's, his own motion calendar never falls behind. One of his former law clerks told me that during his clerkship, he never took a day off for 6 months straight, but he also recounts how whenever he was in chambers, Judge Tashima was always, always there. And I think that's the same for all of us. It didn't matter if I came in early at the crack of dawn or if I worked late into the wee hours of the night, if I came on weekends, Judge Tashima was always there working with us. And the incredible thing about all of this is that despite keeping up this alarming pace for 39 years, Judge Tashima maintains such a cheerful attitude about it all. He has such a contagious liveliness and spirit for his work. He's really led the finest example of how to have fun while doing a gargantuan volume of work. And I think he's really inspired all of us to find something that we love to do with the same fervor, passion, and enthusiasm. Another quality that all of Judge Tashima's former clerks find most memorable is his complete unflappability in the face of any and all problems, fastballs, curveballs, frustrations, aggravations. It's just impossible to ruffle him because he has seen it all. Throughout it all, he is steady, careful, confident, involved, caring, brilliant, witty. He demonstrates the highest integrity and impeccable collegiality to all of his colleagues on the bench, and he's just an excellent professional model that all of us wish that we could live up to more fully. So in particular, I want to share with you 2 vignettes from former law clerks that I think really highlight how the judge has touched our lives and had such a profound influence on our careers. The first of these relates to, well, Judge Tashima has always had this great tradition of going out to lunch with his current law clerks about once a week. And this one particular year, it was every Friday that the judge was in town, and the clerks really appreciated it. It was a great way for them to catch up with him socially. Well, on the Friday that the bar examination results were going to be announced, these 3 law clerks, they went out to lunch with the judge as usual, and understandably they were nervous wrecks during this lunch. And at the end, when the check came, the judge grabbed the bill and he told them all, "I have this. I want to congratulate you all on passing the bar." Now, these 3 law clerks, they got ecstatic because they thought, wow, these 9th Circuit judges, they must get some secret list to tell them that who passed. So they were ecstatic, and but then the judge had to clarify with his signature smile, "Oh no, I didn't see any lists, but I just have never had any of my law clerks, and you are not going to be the first." Okay. Now the second anecdote illustrates mentoring on a more personal rather than a professional subject matter. This former law clerk used to smoke, and he was a smoker when he was clerking for Judge Tashima. So one day he and Judge Tashima were talking about smoking, and the judge told him that the judge used to smoke as well. So this clerk asked the judge, "Well, how did you quit?" And the judge told him that, well, when the judge was in the military, one of his superiors caught him smoking when he wasn't supposed to be smoking. So that commander made Judge Tashima put stuff a dozen cigarettes into his mouth all at once, lit them, and made him smoke them all at the same time with a bucket over his head. And this made the judge so physically ill that after that incident, he quit cold turkey, and he has never had a cigarette again after that incident. Well, the judge told this story to this former law clerk, in his typical no-nonsense, understated way. And this law clerk tells me that he still doesn't know if this is a true story. But he says it was just the gentle nudge that he needed to have the confidence that he too could overcome smoking and quit cold turkey with some focus. So I'm happy to report, Judge, that if sometime after this, when this law clerk found out that he was having his first child, he too, he remembered this story from the judge, and it inspired him to have the confidence to know that he could just quit cold turkey, and he hasn't had a cigarette since. He figured if the judge could do it, so could he. So I have to tell you, I love hearing all these stories from former Tashima law clerks, because I think that all of us have felt the judge's steady and quietly encouraging presence in our lives. He never puts any pressure on anyone, but he gives us this quiet, calm confidence. And we know that we can never achieve his brilliance, his humor and wit, and his wisdom. But Judge Tashima really gave us the confidence that we can follow his example, infuse our work with that same bounce and vigor, and achieve whatever goals that we set for ourselves. So even though I haven't met all of Judge Tashima's former law clerks, I feel a sense of kinship with each and every one of them. And that's because I think we all have this sense of having shared in a relationship that was truly special. We all have pride in playing a small role in his big chambers, and we are so grateful for all that he has taught us as our lifelong mentor. Thank you.
I feel like I should be apologizing to all the judges in the room for walking through the wells. So. My
My name is Michael Roth. I graduated UCLA Law School in 2001. When I was a second year, Frank Menendez was the editor-in-chief of the Law Review, and I wrote on, and my son was born during my second year of law school. I graduated and I went to work for Latham & Watkins. This was in September of 2001, and it was right after the dot-com bust and right before 9/11. I thought I was going to be a transactional lawyer, and suddenly there's no transactional work, and so I ended up doing insurance law for a year, and litigating, defending insurance companies, and then I went and clerked on the district court, and I clerked for Judge Marshall, who we've heard from earlier today. And I was getting toward the end of my clerkship, and Judge Marshall says to me, "You really need to go talk to Judge Tashima." And at that time, he held a clerkship spot for clerks coming out of the district court. And so I interviewed with Judge Tashima, and when he offered me a clerkship, it was a moment that changed my life. So the first thing that happened was Candace called me up, and she said, "You actually have to start early." And I was like, "What do you mean I have to start early? I'm finishing up a clerkship. I've got 12 summary judgment motions I've got to deal with." And she says, "No, we've got this calendar, and what do you know about?" And I said, "Well, I kind of know about insurance law, and I kind of know about district court procedure." She's like, "I've got the perfect case for you." And so, I don't know if you guys all remember this, but the cases are weighted on the Court of Appeal, and this was like an 8-weight case. And this is one of Judge Tashima's most unremarkable cases ever. I don't think anybody ever cited it. We've heard all these great cases, but this was called McGregor versus the Paul Revere Life Insurance Company. Nobody's ever cited to it. And it had to do with a trial about disability benefits for a court report. And so the appeal concerned the evidence that came in, the jury instructions that were given, the closing arguments, the post-trial motions, and I wrote a 75-page bench. And I met Judge Tashima once. And I came into chambers on a Friday, and Candace told me that I had to unbind it. And I was like, "What are you talking about?" So she shows me this prehistoric machine. You have to like put holes into it and put that like plastic thing. And I was like, I sat there for like an hour and I couldn't like figure out what to do. I'm like, Candace is one of my dear friends, and I'm like, "What have you gotten me into?" At this point, I'm like, we didn't get off on the right foot. And I went in and I talked to Judge Tashima about the bench memo, and I went into his office, and there are 3 things we talked about, and those things have kind of stuck with me forever. And the first one, and we've heard it from all of you guys today, is be right and direct and concise about the facts and the law. And he said, "You did that." And he said, "And you know why this matters to people?" And I was able to talk about that with him. And I was nervous about clerking, and he was like, "You're going to be okay." And then he said, "Let's go meet the other clerks and go to lunch." And that's the third lesson. It's like, enjoy great food with your colleagues. So on Wednesday, I was arguing a case in front of the Third Circuit Court of Appeals, and this was kind of stunning today because all of this talk about procedural justice today, and the words actually came out of my mouth during the argument that we have a system of orderly justice and the procedure we have matters to people. And that was actually the argument I made to the Third Circuit, but as I was preparing, I was thinking, oh, what are the 3 things that matter? And what are the facts in the law, and be right and concise about it? And I was thinking, only if I knew a circuit court judge who I could ask and like get some advice, but I didn't call up Judge Tashima because like every good practitioner, he comes to work with me every day. And I looked in my book and pretty confident I was right on the law. And then I started my argument, and I'm 10 seconds into it, and the first question that I got asked is, "For the life of me, I can't figure out why this matters to your client." And I was like, okay, but I was ready to answer that one too. And when the argument was done, I went out with my colleagues and my client, and we enjoyed a great meal together. And I came back from Philadelphia, and I was thinking, I had this great experience, and every practitioner has this book, and I was thinking to myself, how many times has this book been cited to? And so I went onto Westlaw, like some of the people earlier, and much to my dismay, in Westlaw Next, you can't tell how many times people have cited to the rudder guy. And for those of you who went to law school when I did, or before, we actually learned to shepherdize in the red books, and we sat in the library and did all that, and what no junior lawyer knows how to do anymore. And the changes in Westlaw have been very frustrating. So then I went, okay, so if I can't cite to figure out how many times people have cited to the rudder guide, I actually did the same thing as some Professor Milligan. I figured what cases have been cited to the most. And the first case I had never heard of before. And it was a case called Moss versus U.S. Secret Service, and it had been cited to 11,450 times. And I was like, oh my gosh, what in the world did Judge Tashima fight about? And this will not surprise anybody, because it was a civil rights case, and it had to do with a claim that the Secret Service was discriminating against protesters who were protesting George W. Bush, and they were discriminating against, treating them differently than the people who were protesting for George W. Bush. And it was the first case in the Ninth Circuit that really applied the new pleading standard from Iqbal and Twombly. And it's been cited to thousands of times for that. And the result is very consistent with what everybody's talked about. Judge Tashima ruled that the plaintiff hadn't met the pleading standard from Iqbal, but there was a change in the law, so they definitely should get leave to amend. And he gave very short shrift to the government's idea that you could get summary judgments against the plaintiffs without letting them have discovery. So then I looked at the list of what was the second most cited case, and lo and behold, it was a case from when I clerked, and that had been cited to 6,453 times, and I'm responsible for, I think, 12 of them. So I was kind of excited about that. I didn't actually work on the case, but John Montreal, who I worked with, he talked about the Vargas Maya case, which I worked on, and this was his case, and it was a case involving Evel Knievel. And there was a photo of Evel Knievel and his wife, Crystal, at the ESPN Action Sports and Music Awards in 2001. And Evel Knievel was wearing a motorcycle jacket and rose-tinted glasses, and had his arms around his wife and another young woman. And there was a photo taken of them, and it was posted on the ESPN website. And there was a caption that said, "Evel Knievel proves that you're never too old to be a pimp." And Evel Knievel sued ESPN for defamation. And this was a case on the pleadings. And so we all know Judge Tashima has a very wry sense of humor. And there's this wonderful opinion talking about Evel Knievel and his amazing jumps over the Grand Canyon and all of his incredible feats. And in the middle of the opinion, there's a discussion about the pleading standards. And as we all know, there's so many civil procedure professors here. This is kind of amazing. And it's, under 12b-6, you're confined to the pleadings. But what do you do with a photo from a website? And this was the first case that used the incorporation by reference doctrine for a website. And what Judge Tashima held was that you can look at the entire website. And when you look at the entire website, he came to the conclusion when you call somebody a pimp and it's Evel Knievel, you're actually complimenting them and it's not defamation. So I've cited to this case many times. And I used it in a case before Judge G. It was a case brought by the Red Hot Chili Peppers concerning Californication and a television show. I've used it in a case with a shock jock went on the radio and offered money for somebody to go out and kill Penn Jillette. And I've used it to incorporate by reference Airbnb's website. And it's a small opinion that it has had a great reach. Through my clerkship, I was getting to the end of my clerkship, and my son was 3. My wife was going through chemotherapy, and I was trying to figure out what I wanted to do. And I was one of those guys that was like, I'm not sure I can go back to a big firm. And Naomi says to me, you have to go interview with Chris Caldwell and Mike Leslie, who are both former clerks of Judge Tashima, his early clerks. And I went into Judge Tashima's office and I said, Judge, what do you think about these guys, Caldwell Leslie? I was at Latham, I can go back there. And he's just said, that would be a good place for you. And so after interviewing with Chris and Mike 7 or 8 times, they offered me a job, and I've worked with them for 15 years. And we currently have 6 of Judge Tashima's clerks. And the one thing that is very consistent with all of the clerks who come from, who have clerked for Judge Tashima, who come to work for us, they all write incredibly well. You can describe the facts accurately. They can all say why it matters, and most of all, at the end of the day, they all like to go out and enjoy a really wonderful meal together.
Okay, so thank you everybody, that was amazing. Does anyone have any questions, or for this one, maybe if you have a comment or anecdote that you want to share or add, be welcome to. So anyone? Yes, Eileen.
This is a wonderful symposium. But I'm not hearing a whole lot about the judge as a district court judge. And the cut and paste generation, who really cut and paste. I learned one of my most valuable lessons about pleading. This was pre-Twickball, and it was under the old Conley standard of a case should not be dismissed for failure to state a claim unless there's no set of facts on which it could be decided. And there was a fellow in this town named Steve Yagman. And he was a civil rights lawyer, and he would file pleadings that were the worst examples of complaints I had ever seen. They essentially were identical pleadings against the LAPD. And this, of course, was before Rampart and before Rodney King. So this little girl from Minnesota looked at these pleadings and thought, if ever there was a pleading that should fail Conley, it's these complaints from Yagman that are basically mimeographed. And so I went into the judge and I said, Judge, we have to do something. You know, we have to dismiss these complaints. And the judge said, you don't understand. He's suing the LAPD. And there's no way he's gonna get the facts that he needs until this case goes into discovery. So we're not gonna dismiss these complaints. And we didn't. So, you know, he's done a lot of justice. He's done a lot of justice as an appellate judge, but he did a lot of justice as a district judge too. And I'm very proud of him for that.
I'm one of the people that Mike Roth referred to that was literally going through the Shepherds and cutting and pasting, literally would reorganize their memos by Xeroxing them, cutting them, taping them on, and then Xeroxing them again. And the judge was very kind that he allowed us to do that, because I went to law school back in the day when not that many people knew how to type, certainly not men like me knew how to type, so it was very laborious for me to type. But what I learned from Judge Tashima was that he was always one step ahead of everybody. And I learned that once when I went in with the bench memo. I had gone through the Shepherds, the supplements to the supplements, and gone to the ever thinner supplements, and I was convinced that the law was accurate. And I went in, showed him the bench memo, he read it and said, well, did you read the Daily Journal Daily Appellate Report this morning? I said, no, what's that? The case just came down from the Ninth Circuit, and it basically vitiates your entire memo. Go back, get your scissors, get your tape, redo it. And so then I was in court maybe 2 months later, and there was a preliminary injunction motion on some, I think it was an antitrust case, which of course the judge really knows. And can't even remember the particular circumstance, but there was the judge, or the lawyer for the plaintiffs, stayed him all night, the young guy, this was his big case. He went through his whole argument, and then the judge said, counsel, did you read the Daily Appellate Report this morning? And I sort of said, uh-oh. And he said, no. And he said, well, you might want to go back and look at this case because the Ninth Circuit just changed the standard. And the guy just stood there, and he literally stood there, and then he just fell right over something, fainted dead away. I don't know if you remember that, Judge. But, so the whole courtroom was silent. We were looking at this guy on the floor. The judge said, I think we better call the marshal and take a recess. So he revived. The guy said he hadn't eaten for 24 hours. So he could go back and read the case. Could he please have a continuance? And of course, he got a continuance. But anyway, that's so. Ever since then, and to this day, I always read the Daily Appellate Report, and also that little LACPA thing that comes out with every case. So, lesson learned.
So Judge Tashima taught me two things. One, I think as many people have talked about, how to write. And I was sort of coming from law school, but also coming from graduate school in English, so I think my writing style was best described as flowery. And Judge Tashima was very, very kind. And I remember telling my co-clerk, Natalie here, it was one of my greatest triumphs was when there was one whole sentence I wrote in a draft opinion which actually made it unscathed. Right? So we were talking about, oh, you know, some needed more editing, some needed less. I was on the more editing. The other thing that I realize now was sort of equally important since it's been 20 years since I clerked, you know, is that he taught me how to adult, to use the modern parlance, because you know, I was. You know, he would, when we go sit at various places, but especially in San Francisco, we go out for not just lunch, but these wonderful, wonderful dinners. And so I remember the first time we did that, Judge Tashima was like, you're only ordering vegetables? At that point, I was a militant vegetarian. He's like, no. He's like, you know, you're gonna try something else. You know, and so really sort of encouraged me to eat. And then would also, I don't remember this, would give us the wine menu, say, all right, you gotta order. And we'd be like, oh, okay. He's like, no, this is something you need to learn, right? So it was really, I mean, not just sort of a finishing school for writing, but how to be, you know, how to enjoy life while working really hard. And so, I mean, I think both of those have been equally valuable sort of in my career and daily life.
This is also going back to something Halim was talking about how Judge Tashima is so great to the women and moms in this chamber. I had a 6-month-old when I started working for Judge Tashima, and had you know, on these trips that we would go on, would have to pump while we were gone, and so that involved like calls to courthouses and stuff to like find a place. But there was one time that I was traveling back. It must have been on the same flight with the judge. And the TSA screener stopped and demanded to like individually swab like each bag of breast milk I was bringing back. And I'm like, oh my God, like the judge had gone first. And he just very patiently waited. And it made it like completely not awkward. And then the TSA handed it back to me and we went on our flight. And I was so impressed that's been a story that I've told many times over the years to young lawyers about the type of respect that you should expect from employers and coworkers when you are doing your job, and need some accommodations as well.
So I remember there's something that Judge Lou said about Judge Tashima just going right to the heart of the matter in a way. And there's a story that I remember from when I was clerking. It was an oral argument, and I don't remember all the details of the case, except that everyone was very animated. There was a lot of back and forth between the judges and counsel, but Judge Tashima was very quiet, and I was watching the argument. And he was so quiet, and I think thinking so much that I actually wondered for a moment if he was asleep. He was kind of sitting kind of like this, and did he just fall asleep? Just as I was kind of about to think the answer was yes, he popped up his head and he said, "What makes you think we have subject matter jurisdiction?" And everybody in the room went, There's no subject matter jurisdiction, that was the end of it. Nobody fainted that time. I would just like to thank Judge Tashima for hiring UCLA law students. It was 20 years ago, and there really weren't many circuit judges who would hire UCLA students. I don't know if that's changed a lot, but there were many who wouldn't. So I just want to thank you. Obviously there are many UCLA law people here today, and you changed all of our lives, so thank you.
Okay, so it's actually time to hear from Judge Tashima himself, and he's graciously agreed to share a few words with us. And so, Judge A. Wallace Tashima.
I don't have too many notes. Thank you very much. Thank you for this day. But it's been a long one. The best thing I can do for you is to make you the same promise that Elizabeth Taylor made to her seventh husband-to-be. I won't keep you long. Where do we start? There's been talk about advancing justice. Reminds me of one of my real legal heroes, Emiliano Zapata, the great legal reformer. And what he said was, for my friends, justice; for my enemies, the law. I think I'll start by also maybe telling you a little story about myself. I guess it's now 60 years ago, when I was a first-year law student, there was a big trial about to start in the federal court in Boston. Senator Owen Brewster of Maine sued the Boston trial for libel. The newspaper had published a story, I think, strongly, at least implying that Senator Brewster had accepted a bribe, and of course he had to sue for libel. A group of us, first-year students, decided, we should go down to the Scully Square courthouse and watch the trial. It would be probably just as educational as staying at school and going to class. So we went to the trial. In those days, trials didn't take long. This was a big libel trial. It lasted 3 days. But boy, I enjoyed every second of it. It was in that great old courthouse on Scully Square. With a lot of drama. But most of all, I was impressed with the presiding judge, Judge Charles Wazansky, who was a legend in his time. And it was clear to me that the best seat in the House was Judge Wazansky's seat. And that trial, I think, by the way, the 3-day trial lasted or resulted in a verdict for the plaintiff, Senator Brewster, and he was awarded the nominal damages of $1. Of course, both sides immediately claimed that they had won. But it was clear to me that, after watching that trial, that was my dream job, to become a federal district judge. And so I knew it was, at best a distant dream. But still, it stayed with me, and some people have talked about, I became a trial lawyer. I tried a lot of cases. I did learn to be a trial lawyer, and I enjoyed it. But my aim always was to be a federal district judge. I had the opportunity to become a state court judge, but I was not interested in that. I want to be a federal judge. But my opportunity came when in 1976 President Carter won the election. he and his Attorney General, Griffin Bell, made it clear they wanted to diversify the federal judiciary. And for the district courts, encouraged the senators who had probably more say then than now, to establish a merit selection commissions. And to my delight, Senator Cranston, who was the senior senator from California, appointed probably my best friend to be the chairman of the California Merit Selection Commission. At that moment, I realized I had a lot of merit. And sure enough, you know, my time came, and Sam recommended me to, and the commission recommended me to the senator, and I don't think the senator ever turned him down on a recommendation. So I got my commission to become a judge of the Central District of California. And I'd been, and that was about 1980. So I've been a federal judge now, trial judge and appellate judge for almost 40 years. I feel extremely fortunate to have had the opportunity to, in effect, be a steward of the federal judiciary for all these years. To be a steward, I think, of the judiciary means that I think we have the obligation to protect the institution and to protect the values, to keep our judiciary impartial and independent, and to protect the rule of law. If we faithfully perform our stewardship, we will hopefully leave the judiciary and the concept of the rule of law more strongly embedded in the next generation than when we received it. I think that is a duty, and that should be the aim of those of us who have the good fortune to become federal judges and stewards of the judicial system. There's been some talk about legacy, and I think it was said correctly today that perhaps the most lasting and important legacy that a federal judge leaves is really the law clerks that work on way after his or her work life is ended. And I've had, I think, the great fortune to have just tremendous law clerks. To some of my, I haven't said to all of them, but I said to a number of people I've interviewed, I said, you know, I think probably every law clerk candidate I've ever interviewed, I know is smarter than I am. You know, just that maybe I've had more experience, but it's I don't understand why really so many, it's hard to understand why so many capable law students want to become clerks. You know, it pays less than the going wage. Sometimes the hours are worse, but nevertheless, there's a whole stream of very, very, very capable young men, young women who want to be clerks. And it's been my good fortune to have just wonderful clerks, smart, lawyerly, good people, fun to be around. Even the ones, you know, I've had several who've left the law. Maybe they're the smart ones, I don't know. I've had several who've left the law. I can't tell you what all they're doing, but one I know is a movie producer. But they range from that to another is a prison psychologist. But you know, and a third went back to teaching high school. But still, the bulk have remained in the law in one way or the other. As teachers, judges, lawyers, and I think the profession is stronger for it. The judiciary is stronger for having had all you people as clerks. And so I thank all of you, not just for the stay today, but for the great privilege it's been mine to have such an army of such wonderful clerks. Thank you very much.